Yeah, please, Lordship.
Mm.
But sir, back to mention item number 35, my lord. The matter is plus, my lord. Petitionary dream.
35.
Lordship, I have
35.
received instruction also, my lord, in this.
Item number 35.
The petitioner has been reinstated, my lord.
The suspension matter.
My lord.
Your name?
P. Bora.
But Mr. B. Bora, the learned counsel appearing on behalf of the appearing on behalf of the petitioner. Ms. M. Deborah appears on behalf of the
Standing Council Transport Department for all the respondents.
appears on behalf of the Transport Department. The counsel for the petitioner had submitted that the instant writ petition has become infructuous in view of an order dated 26/6/2023 passed by the Commissioner of Transport, whereby the petitioner has been reinstated. The said order dated 26/6/2023 was placed before this court during the course of hearing. In that view of the matter, the instant petition stands closed as infructuous. The order dated 26/6/2023 is made a part of the record and marked with the letter X.
I am obliged, ma'am.
May I please, your lordship?
I do.
With the consent of the other side, I beg to mention item 33.
Yes.
KK Parasar is having medical condition.
Who?
KK Parasar.
Hmm.
His wife
Okay.
is.
At the request of the learned counsel for the respondent, matter stands adjourned for 4 weeks.
Obliged.
May I please, Lord. My lord, I beg to mention item number 40.
40?
Yes, ma'am.
40 is where? Okay.
My lord, similar 8-9 matters are already fixed by this honorable court on 19, my lord, 19/7.
What is this matter?
Is regarding certain stoppage of salary of the petitioner.
Okay. At the request, Mr. J. Abidin, the learned counsel appearing on behalf of the petitioner, submits that similar matters are fixed on
19/7.
19th of July 2023. Accordingly, he submits that the instant writ petition be tagged along with WPC number
7317
of
of 2022.
2022. List accordingly.
Deploy.
Okay. I beg to mention item number 41 to 43, Lordship. In this case, Lordship, I am going to file, Lordship, a impleading petition, Lordship. The matter, Lordship, adjourned for the bail, Lordship.
You have filed?
Impleading petition, Lordship.
Have you filed?
No, Lordship. Going to file, Lordship, on Friday, Lordship. So matter maybe it's after.
Have you filed Wakalatama?
Yes, sir. My name is Jal.
What is your name?
Bhima Lakal, Lordship.
You are a petitioner.
I am the petitioner.
You wanted to file an impleading
Impleading
application.
petition, Lordship. That is, Lordship, after liquidation of the Hindustan Paper Corporation, Lordship.
Oh.
Official liquidator, Lordship, is to be made party.
What are these matters though?
Lordship, there are two matters. One, Lordship, suspension, Lordship, and dismissal, Lordship. And last, Lordship, 15 matter, Lordship, is regarding, Lordship, leave salary and other retirement benefit. This is two matters.
But Mr. Counsel, HPC, more particularly the all other units except one unit outside, all are out have already gone into liquidation.
Yes, Lordship.
Then why you are not approaching the authorities? They have already the resolution have already been approved by the NCLT. So under such circumstances, don't you have to move before the CRP? The RP, the resolution professional. Then you can't help it because we can't make the resolution professional a party. Now you are as regards a suspension.
Lordship,
And more particularly recovery of salary, how will it have, you can do anything out here. Those are claims which are to be made there.
Lordship, I have to file representation before the official liquidator, Lordship.
So if you have
Yes,
done
sir,
it, then
Lordship,
wouldn't that be a subsequent cause of action?
Lordship, they have stated that, Lordship, is a dependency of the writ petition, Lordship.
Hmm.
There is no specific order, Lordship. That my suspension period or special period. But there is no special order, so that my leave salary and other retirement period not be.
Because those are to be taken into account. There is a particular manner in which, more particularly if you see section 33 of the Insolvency Bankruptcy Code, then what to do?
Also kindly pass for the matter.
At the request of Mr. B. Malakar, the learned counsel appearing on behalf of the petitioner, the instant writ petition stands adjourned to be listed after summer vacations. Yes, madam.
Please, your lordship, I beg to mention for listing of a motion on Friday
Matter pertains to,
pertains to non-payment of pension lordship mention and provisional pension.
we have got the provisional pension.
No,
Okay, we'll have it tomorrow.
Obliged.
You have filed it?
Yes, sir. Yesterday I filed.
Lordship, I beg to mention number item 3, where engaged counsel T.K. Bhoya, his mother, day before yesterday, his mother expired. So he was not in Guwahati.
Okay.
Please list before matter after vacation.
At the request of the learned counsel for the petitioner, matter stands adjourned for to be listed after vacations.
Please clear.
I am appearing for the department,
You are appearing for
corporation department, madam.
Ms. M. Deborah appears on behalf of the corporation.
Yep, your blessing.
Lordship, I'm like to mention item number 11. My
Yes.
learned friend is appearing for the private respondents.
Yes,
This matter pertains to pension. I am for the second wife. Now we have both decided that we will like to share the amount. So we will both start together and my party will come and his party will come. We would like to sit together and sort out. So I pray for some time.
you want to file an affidavit?
Joint,
Affidavit.
if it is material issue,
If it is
then
material,
joint affidavit.
Let
will
us
be
try for that.
Or
I have proposed it.
Mr. K.K. Nandi,
Yes, ma'am.
the learned counsel appearing on behalf of the petitioner. Mr. D. Nandi appears for the respondent,
fine. Respondent number
number 10.
first.
The instant matter pertains to the entitlement of the family pension. It has been submitted at the bar by the learned counsels appearing for the petition and the respondent number 10 that there is a possibility of an amicable resolution amongst them. And as such, if possible, they would be filing a joint affidavit. And for which an accommodation is sought for. Let's the matter again on 7th of August.
Upright.
Item number 1 for motion.
Okay, none appears. I can't help it. None appears on behalf of the petitioner on call. And so and so. And appears on behalf of which department?
PNRD department.
PNRD department. List the matter after summer vacations.
Item number 2.
Yes,
Petitioners are praying for, these are assistant teachers, okay? They are praying for pension to be governed under Assam Service Pension Rules 1969.
who are you?
I am an assistant teacher.
Assistant teacher brought under what scheme?
Brought under the selection process and joined on 3/12/1993, okay?
You have been appointed. Show me your appointment letter.
Yes, 22 lot.
Matter A 22 please.
What is this type of appointment? Temporary appointment you give with stipendary, with a regular pay scale. How is it? This can't be a appointment in terms with your what do you call that, service elementary one? 82 or 77? It can't be.
Lordship.
When were you brought? Yeah, excess teacher.
Yes.
We dismiss it?
Similarly,
There's no similarly. I have already dismissed it. Similarly.
WPC 6403.
Ah, dismissed. Heard Mr.
As this.
To enter the learned counsel appearing on behalf of the petitioner. Mr. P.N. Sharma appears. No finance? Yeah, the finance. Yeah.
I'm for 1 and 2, Lordship.
Mr. P.N. Sharma appears on behalf of the respondent numbers
1 and 2.
1 and 2. Mr. S.R. Borua appears for respondent number 3. Mr. B. Gogoi appears for respondent number 4. The instant writ petition, taking into account the issue involved, which is covered by the judgment of this court in the case of Purnima Hor versus State of Assam, reported in Ekatidi. So in this case, the instant writ petition is taken up for disposal at the stage of motion itself. The claim of the petitioners herein is that the petitioner was initially appointed in the year on 1/12/1993, and subsequent thereto, there was an exercise carried out and it was found that the petitioner, appointment of the petitioner was in excess of the posts sanctioned. Accordingly, the petitioner was brought into the affairs of the government, brought into the services of the government by an order dated 11th of August 2005. In the said order dated 11th of August 2005, it was categorically mentioned that the petitioner's services would be regulated under the new pension scheme, which were being formulated in line with the contributory pension scheme of the Government of India and would be notified in due course. It is further relevant to take note of that on, what is the date on which it was notified? 6/9/2009, something. It is relevant to take note of that on 6/10/2009, an office memorandum was issued by the Finance Budget Department, whereby the new defined contribution pension scheme was notified. In terms with the said scheme, it was made clear that the scheme would be applicable to all new entrants joining the government services on regular basis against vacant sanction posts on or after 1/2/2005. It further reveals, it is further relevant to take note of that on that by the notification, by an amendment made by the Assam Service bracket Pension bracket Amendment Rules 2011. Rule 2A was inserted by the notification dated was inserted, stating into whereby stipulating therein that the Assam Service Pension Rules 1969 shall not apply to government servants appointed on or after 1/2/2005 to the services and posts in connection with the affairs of the state governments of Assam, which are born on pensionable establishments, whether temporary or permanent. And such employees shall be governed by the new defined contribution pension scheme 2009. This court had the occasion of dealing with a similar proceedings in the case of Purnima Hor and another. In the case of Purnima Hor, it was 2023 SCC Online GAU 1165. Supra, wherein the issue pertaining to excess as to whether the excess teachers would be governed under the new pension scheme or as per the Assam Service Pension Rules 1969 was decided. In the said judgment, at paragraph number 111, this court held that the teachers so appointed as excess teachers, teachers who were appointed in excess of the post during the period from 1/3/1991 to 30/11/1996 would be governed by the new pension scheme, new new defined contributory pension scheme, and not under the Assam Service Pension Rules 1969. In that view of the matter, the instant writ petition is duly covered by the said judgment and accordingly stands dismissed. However, before parting with the record, this court, however, finds it relevant also to take note of, finds it relevant to observe that the petitioners herein shall be eligible for the benefit of retirement gratuity and death gratuity on the same terms and conditions as are applicable to employees covered by the Assam Service Pension Rules 1969 in view of the office memorandum dated 1/2/2011. With the above, the instant petition therefore stands dismissed subject to the observations made in paragraph A, paragraph 2. Itu dia dulu before parting. Itu.
Item number 4.
My lord.
Hmm,
My lord, petitioner was appointed as Hindi teacher prior to 2012, my lord.
hmm.
Take up the case is that, my lord, as he is year degree holder, my lord, to entitle for one advantage.
Oh, this one.
Yes, my lord.
Who is appearing for whom?
I'm
PTC is there? Okay. 1 and 2 by
G Thakuria, Lordship, secondary.
so and so. Appears Nam to did you.
G Thakuria.
P. Thakuria for respond number 1 and 2, and
P.
Mr. R.K. Musari appears for respond number 3 and 4. Dispose of করি হ্যাঁ এই লাস্ট অর্ডারটো ইয়াত আছে আপুনি এনেকুৱা আপুনিয়ে মাৰিছে 24/3/2023 page 49
But she is Hindi teacher, my
হিন্দি টিচার লিখি দিব দেই এসিস্ট্যান্ট টিচার নে লিখিব হিন্দি টিচার
5.
হিন্দি টিচার টি আপনার yes Mr. Fukan
If,
transfer
actually, it's not,
what are you asking for
that the petitioner is presently posted at DI of
the
the school at
petitioner at the
Nalbari,
office of DI school looking into the hardship. Oh, petitioner is what?
He is working as a senior assistant in the establishment of deputy inspector of schools at Nalbari, Lord.
You are?
Senior assistant, Lordship.
Oh,
Deputy in the
you
establishment,
are not teacher.
not.
Okay, now what do you want?
Lordship, I have made a prayer, Lordship,
Ah,
for posting me at my home station at Lokhimpur, Lord,
hmm,
by filing a representation, Lordship.
hmm.
Now, why I am submitting that representation, because, my lord, earlier in the year 2021, Lordship,
Mm.
I was transferred from my home station to the Nalbari district, Lordship. By the Lordship transfer order, that is an annexure 2, Lord.
Why are we going to Nepal for having a cataract? Then you have no problems. Tell me, you have a problem. You have been transferred. Where do you want to go?
Nearby to my home station, Lord, at Lokhimpur.
Why? Why? And where are you in Nalbari?
That's why I have submitted that representation, citing 3 grounds, Lordship. First one is that my wife is working in the Lokhimpur district as a teacher, Lordship.
Ah,
And secondly, my lord, I have a 5 years old little son, Lordship. And another is, my lord, due to this present health condition, Lord.
hmm. You were transferred when?
In the year 2021, Lordship, 16th of July 2021, Lordship. 20.
Then
That is under Salem, Lordship. And that,
is your post transferable?
Lordship.
Then why should I?
That transfer order is
You want the consideration of the representation,
Lordship, Lord.
which this court is very bad in giving.
Because, my lord, this transfer order is under Salem.
You challenged the transfer order earlier.
That is
What has happened?
That is under Salem, my lord, because that restriction is still pending, Lord. And
So file an IA there. What is there to do with this?
that, my lord, during pending.
Are you not circumventing the said process by again filing another petition?
Yeah, my lord, I am.
We'll do one thing.
Lord.
I'll just issue notice, fix it along with that
Lord.
matter.
Lord.
Heard Mr. R. Pukon, the learned counsel, appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of,
Respondent number 1, 2, and 3, all the respondents. Lord.
appears on behalf of all the respondents. To issue notice, making it returnable. When is the petition fixed? That one?
After 6/8/2021, it has not been listed, Lord.
Okay. Issue notice, making it returnable on 9th of August 2023. The petitioner is directed to take effect notice upon all the respondents by serving extra copies of the writ petition upon Mr. P.N. Sharma, the learned counsel, appearing on behalf of the respondents. It appears from the records that the petitioner was transferred from the office of the district elementary education officer of office of the officer in Lakhimpur to the office of the deputy inspector of schools Nalbari by an order dated 16/7/2021. The petitioner challenged the said order by way of a writ petition being WPC number 3455/2021. Was there a stay?
Yes, Lord.
Then what happened?
Lord, it was extended on 6/8/2021, Lord. That is an annexed C, Lord. So annexed
Then
Then, my lord, on 6/8/2021, notice was issued, lordship.
where?
And my lord, page 21, lordship, last paragraph 6, lordship.
Shall continue till then.
Lord.
Then
Then lordship, it was,
Huh?
Well, it has not been listed on, we have also not filed any pension.
then what happened?
It has not been listed thereafter, Lord.
Understood, but what happened thereafter?
Thereafter, lordship, this order was, they have passed, lordship.
Then you went because there was not the matter was not listed, you joined there.
Lordship.
And after you submitted this. Then why didn't you file an IA there? Instead of joining out there.
So, I think, abiding, lordship,
Very much more abiding. Huh? So you left that particular place, handed over charge. That means this repetition has become infructuous. Don't you think that?
There's some consideration given by this honorable court because we have taken some other grounds in that.
Anyways, issue notice made a returnable on, we fixed it earlier. On 26th of July. Steps hetu kori dibo, Mr. P.N. Sharma so and so. Taking into account that the instant repetition is intricately connected to WPC number 3455/2021, lists the instant repetition on the returnable date along with WPC number 3455/2021. You get your instructions, Mr. Sharma.
Lordship.
You have made that repetition infructuous. There was an interim order was there.
Obliged.
6. Hey, बाकी किन लिखने में ना लगे एक कौन से फिर that transfer order होता है किन लिखने में लगा है एक किन्हीं खाली issue notice है किन्हीं कोई वो as the instant repetition is intricately connected with WPC number so and so, list the matter instant repetition on the returnable date along with that. Huh? Yes, Mr. Counsel.
Yes, my lord. Matter pertaining to for releasing leave encashment, my lord, to the petitioner, my lord. Petitioner retired on 2020, my lord. Thereafter, he filed, my lord, several representation, my lord, but till yet, my lord, not much.
Who is the respondent?
Yes, my lord. Union of India and
You are working as what?
yes, my lord, LDC, my LDC, my lord, War Divisional Clerk, my lord.
Where?
Yes, my lord, in the office of my lord, Regional Drugs Laboratory, Drugs Testing Laboratory. my lord.
Regional drugs
Testing
testing level.
Initially, that was appointed was under my lord.
Have you retired?
Yes, my lord, in the year 2020, my lord.
How is the Director of Health Service relevant here?
My lord. No, my lord, initially, my lord, I was appointed, my lord, year 1993, my lord. Then, my lord, that was my lord, drugs testing laboratory by Director of Health Service, Assam, my lord. Then, my lord, in 2002, that was marched by the Union Ministry of, my lord, Health and Family Welfare Department, my lord, Union of India.
So now you come under the Union of
Yes.
India. What does the Director of Health Service have to do?
Yes, my lord, regional.
Yes, Mr. Gogoi, what business you have?
No, my lord, directly not connected, my lord.
Is the Union, Mr. Mr. Roy, you are there?
Ministry of Health and Family.
To take instruction, Lordship.
Heard, Mr.
M. Kolkata.
M. Koiltal, the learned counsel appearing on behalf of the petitioner. Mr. S.S. Roy appears on behalf of the respondent number 1, 2, and 3. Mr. B. Gogoi appears for respondent number 4. Issue notice making it returnable on when?
Lordship, 4 weeks.
Instructions only. I don't need further more than that.
That is after vacation.
Okay. Issue notice making it returnable on 7th of August. As the respondents are duly represented by the respective councils, extra copies of the petition be served upon them by 30/6/2023. Yeah, I got to do during the course of the decision. I got to file over the. I got to. Anyway. The petitioner herein is aggrieved by the actions of the respondent number 3 in not making payment of the leave encashment benefit as well as the central government employees group insurance scheme 1980 and in not granting the benefits of leave encashment as well as the central government employees group insurance scheme 1980. The respondent numbers 1, 2, and 3 shall obtain necessary instructions in that regard as regards the entitlement of the petitioner and apprise this court on the returnable date.
7.
Yes, Mr. Ahmed, what are you challenging?
My lord, here, the petitioner was already returned on 31/5/2020. And during his service, he was placed under suspension on 8/1/2016. And he was reinstated in service on 13/2/2017. But that career has not been paid.
36/2018.
From 8/1/2016 to 13/2/2017 area,
30.
13/2/2017.
Then
He was reinstated.
Then,
So in between that suspension period, area has not been paid.
but why in the matter of you are saying 8/1/2016 to 36/2018?
18, my lord, and thereafter increment up to 18.
Huh?
Increment up to 18.
What is this? You're
Suspension
making
period
what you call?
as well as the
No,
increment.
no. Your petition is not so clear on this. Why have you filed this petition in this regard? Increment will be different.
It also can page 14.
What page 14? Kindly see 8/1/2000. So your prayer. See the prayer. Why you are not clear on that?
Yes, ma'am.
Why?
Wrong.
Then.
It is 17 and increment up to 18. The also page 14 is clear. Where inspector letter.
That is only for suspension.
Yes, ma'am.
Then,
Page 14 is also can listen.
well, what about the increment?
Increment up to 18.
Where is it
Next.
mentioned? What is your basis of your increment? Tell me. This is up till
Yes, yes.
2017.
Yes, page 15.
Page 15 and 16 is up
16.
till 2017. What? DA so and so. I want to understand this. It is not clear.
No, I will be allowed to correct.
Huh?
I will be allowed to correct. I will be allowed to correct it.
Correct what?
Period.
Prayer.
Period.
You withdraw with liberty. How can you correct it by hand?
No, by petition.
File petition. File a separate petition.
Yes.
Withdraw with liberty. Heard Mr. J. Ahmed, the learned counsel appearing on behalf of the petitioner. Ms. D. Musairi appears on behalf of the Secondary Education Department. Mr. B. Gogo appears for the Finance Department. Full stop. The learned counsel for the petitioner submits that certain details needs to be mentioned in the writ petition, including there is a further requirement of amending of the relief sought for in the writ petition. He therefore submits that he may be permitted to withdraw the instant writ petition with the liberty to file afresh. Taking into account the above submission, this court permits the petitioner to withdraw the instant writ petition and grants the liberty as prayed for. Petition accordingly stands closed on this. It. Yes.
My lord, petitioners, for your lordship, that the employees of Pensionary Municipal Board who had come before this honorable court on the previous occasion for implementation of an order taken by the board in regard to conferment of benefits under the sixth pay commission, the scale as per sixth pay commission. To that effect, my lord, there was a judgment and order passed in favor of the petitioner.
We not to declaring the categorization of the petitioner in terms of the statement. So you are challenging some order.
My lord, I am
No.
basically
On a
on page 61. This is the statement showing the detailed staff of Tinsukia Municipal Board. Now, this is something, no, my lord, this is now a plea that has been taken up by Tinsukia Municipal Board in a writ appeal that is pending before the Honorable Division Bench of this Honorable Court. However, the fact remains that in the earlier round of litigation, my lord, the challenge or the grievance was only to the extent of conferment of benefits under sixth pay scale. And to that effect, judgment and order was passed in favor of the petition. In that writ petition, the petitioners had not made any prayer insofar as the illegal discrimination of the employees of the board is concerned, because that was not the issue at that point of time. In fact, at that point of time, this was not even conveyed to us that we are temporary employees purportedly. This issue was not agitated before the Honorable Single Judge. The issue remained confined to our entitlement to sixth pay scale. To that effect, my lord, the decision was in our favor. Now the matter has gone before the Honorable Division Bench, where my lord, fact that is now thought to be projected by the Tinsukia Municipal Board is that there is a categorization of the employees of Tinsukia Municipal Board, where some categories, some employees are categorized as permanent, while some employees are categorized as temporary. On the same breath, there is
So that is a stand being taken in the writ appeal.
writ appeal filed by the Tinsukia Municipal
So that is
Board.
why you are challenging that categorization.
The categorization, because my lord, my limb of argument against this categorization is on the same breath, they are also contending that for the urban local bodies, there is no staffing pattern till date. In the third pay commission, there was a recommendation to finalize the staffing pattern that is placed before the finance department, which is still under
But
consideration.
Mr. Chakravarti, kindly tell me,
My lord,
within the adjudication of the instant writ petition,
my lord,
have a bearing on the writ appeal in
Cannot.
view of their stand?
Perhaps cannot, my lord, because
Yes.
in the writ appeal, this is not the issue for adjudication. In fact, the latest
No, you
order.
only say that they have taken a stand out there in the writ
The
appeal.
Tinsukia Municipal Board had taken a stand, but your lordship will see.
In the writ appeal.
Yes, in the writ appeal.
And because of that, you are
No,
challenging.
my lord, in the writ appeal, now the recent development is, notwithstanding the plea that has been taken, the honorable division bench has even, in fact, taken a benevolent consideration of the fact that these employees have been serving since 2001. And till now, they have not been conferred with the higher scale. So there was a direction to the Tinsukia Municipal Board for coordination with the Urban Development Department and Finance Department and find out ways for conferment of the benefit. The last order, if your lordship may kindly peruse, dated 1906, that has been passed in the writ appeal, the last order. Now, this order will, my lord, make it clear that things are being decided, moving in our favor in that regard, my lord.
Then, Mr. Chakravarti, shouldn't we list this matter along with the,
Can be done, my lord,
Yes.
because
Yes.
this perhaps will,
yes,
can be done, my lord.
I think that is a better,
Can be done.
heard Mr. D. Chakravarti, the learned counsel appearing on behalf of the petitioner, Mr. Who appears for others?
I'm appearing for one and
Mr. Ardhor appears for respond number
3.
1 and 3.
Who am I appearing with?
Mr. D. Gogoi appears for respond number 2.
I am for 4 to 8, lordship.
Mr. S.R.
SS.
Mr. S.S. Roy appears for respond number 4
4
to
to
8. So upon hearing the learned counsel for the party, this court is of the opinion that the instant writ petition is intricately connected to the proceeding in WA number 373 of 2022, pending before the division bench of this court. Accordingly, this court therefore is of the opinion that the instant writ petition be tagged along with the said writ appeal. The registry is therefore directed to list the instant writ petition along with WPC number WA number 373 of 2022 on 7/8/2023.
If you apply.
In the meantime, my lord, if you will give extra copies, lordship.
I have not issued notice.
Lord.
Apply.
9.
Son is a process server peon. His salary was stopped without any dependent inquiry. The MP notarization page, extra 8, page 35.
Yes, what are you challenging? 2023, where page 35.
20 March,
What are you challenging?
extra 8, page 35. His salary was stopped without departmental inquiry as required under rule 9 of the appeal and distribution rule.
Illegal appointment.
Yes.
Your illegal appointment.
No, I was appointed
Irregular report.
on 1999. For last 23 years, I'm working as a peon.
Where?
And deputy registrar, Nagaon.
Cooperative society.
Yes.
Only I like to highlight.
Oh, Mr. Gogoi, it is not only in
Yes, yes.
your department these things happen. I was only concerned that it is
In-
health department which has all these problems.
Similar cases, other person has filed. I have an extra 10, page 39.
Then
Page 39, 11 is page 40.
Yes, what has happened?
The state this operation of the annexure 8.
And the petitioner is continuing to getting salary, the pay, and also the fact that no department has been initiated or it's this court is appropriate. Yes,
Lordship, actually similar cases, your lordship, arising from the same impugn order has been stayed, your lordship, by court of Honorable Justice Dev Chaudhary and subsequently by Honorable Justice your lordship. So, but however, liberty was granted to the authority, your lordship, to take necessary to initiate necessary proceedings if so required, your lordship, taking the petition.
why have you directed the treasury officer not to pay on the ground of illegal appointment
Lordship.
without coming to a finding or
Lordship.
giving him an opportunity to the effect that his appointment is illegal?
That was, it was held in that no departmental proceedings were done.
No, forget about department. There is another aspect of it. Departmental proceedings will be when he's a regular appointment.
Yeah,
And there is a
yes.
misconduct.
There's a
Yes, yes.
misconduct. But here, if the initial appointment is illegal,
Except irregular.
there might, but you have to, whatever maybe you have to show cause him.
Yes.
Without show cause, can you ask him?
At this stage, your lordship, let me get instruction.
Heard Mr. S.R. Gokoi, the learned counsel appearing on behalf of the counsel. Mr. V. Raskwa
Yes, your for the corporation.
appears on behalf of the respondent,
One to
corporation
five.
respondent numbers
1 to 5.
1 to
5.
1 to 5. Mr. B. Gogoi appears for the respondent number 6. Issue notice making it returnable on, when is the other matters fixed?
On 25th July.
Huh?
25th of July.
25th.
20?
Fifth.
25th of July, issue notice. 25th, why? These are not matters to be listed on such. 25th of July, 25th is Tuesday. Okay, issue notice making it returnable on 25/7/2023. As the respondent are duly represented, extra copies of the writ petition be served upon the learned counsels by 30/6/2023.
The other matters, your lordship, 4 other matters. Your lordship.
It reveals from the records that the petitioner was appointed on 5/11/1999. And thereupon, oh, what is this? In 2015, there was some exercise done.
There
What
was
happened?
One inquiry was done, your
Then
lordship.
what happened?
It was, they were asked to submit the document. your
Understood, but
lordship.
that was,
Thereafter, there was that in regard, I have to take instruction. There's a
A lot of
gap,
times-
gap which is there.
They were asked to give a document. They given a
They
number
could
of
not,
time.
they could not submit the original. application.
thereupon the petitioner continued to render his service. On 21/4/2009, the petitioner was directed by the Deputy Registrar of Cooperative Societies, Nagaon, to submit particulars of their appointment, including his appointment. This was followed by another communication dated 4/4/2011 by the Register of Cooperative Societies, Assam, The petitioner duly submitted his documents, and on 26/8/2015, on 26/8/2015. Thereupon, there was a hearing on 1/9/2015 in the chamber of the Register of Cooperative Societies, Assam. The petitioner thereupon was allowed to continue his services. All of a sudden, on 23/2023, the Register of Cooperative Society directed the Treasury Officer of Nagaon to stop disbursing the salary to the petitioner. Being agreed, the petitioner has approached the court by way of the present petition. The petitioner have also assailed another communication issued by the Deputy Register of Cooperative Society dated 21/3/2023. This court, the learned counsels appearing on behalf of the parties have also drawn the attention of this court to various orders passed by the coordinate benches, including the order dated 14/6/2023 passed in WPC number 3398/2023, wherein this court had stayed the order by which the petitioners therein, the petitioners of those said writ petition had stayed the orders issued by the Register of Cooperative Societies, thereby directing the Treasury Officer to stop their salary. Taking into account the instant matter, this court is also of the opinion that the petitioner has been able to make out a case for grant of similar relief. Accordingly, this court therefore stays the communication dated 2/23/2023 issued by the Register of Cooperative Societies, Assam, as well as the order dated 21/3/2023 issued by the Deputy Register of Cooperative Society, Nagaon, till the next date. Full stop. Liberty is given. Next. But the problem arises that tomorrow, if something happens, what happens to the amount these salaries would be paid?
Obliged.
Number 10.
April of, no, no. Here the order challenge, on the challenge is my transfer order. There is 6/6/2023, my lord. The petitioner is about 59 years is being sought to be transferred to Lunai, my lord.
Where page 56?
My lord?
Page 56.
Yes. He is now on the verge of retirement, my lord. At least 1 year, some months are to go. And my lord, both husband and wife are regular guests of the hospitals, nursing homes, and the training centers. They lost to be seen.
Where are you presently posted?
Presently, my lord, director of statistics of Guwahati.
Transformation and Development Department. What is that department?
Transfer only earlier it was a P&D, I think.
Huh?
Earlier it was Planning and Development Department.
But
And his wife is also ill, with kidney infection and ailment and other diseases. Both husband and wife are regular. They have to go and check up and treatment to different hospitals. I manage the documents starting from page 29 to 57. He has been here only last 18 to 2021. Just completed 2 years. The present person.
you were here from
18 to 2021.
head office at statistical inspector.
Yes.
Where is that? Where is the head office? Directorate of Tea Tribe Development as research assistant. Where is it?
Got it.
Yes,
Yeah,
Mr. Senior Government Advocate, tell me,
Visit department.
you must be aware. These are all at Guwahati.
What?
Then you are here from 2010 onwards.
Oh,
Yes. It appears from paragraph number 3.
yes.
Yes.
I went different office, transferred to this office and to 18 to 2021.
You were here in the head office as statistical inspector from
Yes.
30/12/2010 to 11/7/2016.
Yes.
That is in Guwahati.
And 18 to
Then from there,
18 to 2021.
no, from 12/7/2016 to 5/6/2000, deputed to the director of Tea Tribe Development as research assistant. That is also in Guwahati. Then from 6/9/2019 to 17/2/2012, deputed at Register of Cooperative Society. That is also at Guwahati. Then they are all along in Guwahati.
Earlier he was in Dima Hasao.
When?
Before 2010.
When? Dima Hasao, you were there
Yes.
from 95 to 2000, 5 years.
5 years.
Then at Mongoldoi, as sub-inspector from 2000 to 2010.
Yes.
Then from 2010 to 2023, you are at Guwahati.
Only I'm on, not on that. I'm on, since now he has got about 1 year to go on retirement.
Okay, you want to lessen your period by 1 year. Give an undertaking that you are going to retire next year.
On
Can you-
31st of, yes, 31st of December I'm retiring next year.
You are 58 years old as per your affidavit.
Actually 58 years, now I'm running 7 months.
Huh?
Still 59 years running.
What is your ground?
Ground is that all matter on medical ground of both the sides, smaller and minor son. Wife needs constant care, medical care and other routine care, also domestic care.
The
That's all.
medical report looks
Yes.
very nice. There is no problem.
Wife, she's my more than
Everything
me,
is
my
fine.
wife is
Blood sugar fasting is 112.
that is my matter, but wife is more important.
Then enjoy the life out there tonight. Beautiful.
Joanna, my lord, she will not get any. And my lord, leaving her here also is risky with a minor son. Elder son is outside, man. Here the wife and minor son and the husband. my lord, page 54, wife's report.
Representation is not by you, your wife.
Wife,
And why the petition is by you?
page 55 is my lord, scanned copy of the kidney of my wife. And page 54 is the report.
In your representation, where is it mentioned that there is a problem? At page 58,
My lord, last paragraph, I painfully informed that despite my husband, middle of the academic year of the children, is being transferred into office of the senior officer, July, that is the worth of retirement before completing 1.5 years, should be 1.5 years, my lord, not 2 years.
2.5 years as well. As only in that post. Otherwise, if you see from serial number 5
Yes,
at page 59, you are at Guwahati all along. You may mention Guwahati in one place at number 8. Otherwise, you are mentioning
But the
at
officer-
Khanaparak, Rupnagar, and all comes in Guwahati.
I mean, Guwahati, but different officers, my lord, not in one office.
So what?
He is
You-
senior officer, so he needs to look after the officers. And wherever I'm posted, I've gone. It's not my prerogative of my discussion, it's the discussion of the department. To post me. And nowhere, I submitted Walpara also. The Mahasa also for a long 5 years.
That was long time back.
Yes,
Okay. This court is not inclined to interfere with this.
he's going to return 31, 12, 2024.
When?
31, 12, 2024. Exactly one. That is in the representation also, page 58.
Is there any policy not to retire in the last 2 years?
There is,
Is there any policy?
last 1.5 years, gone.
1.5 years.
1 year is there. 1 year before retirement, one student posted out.
Oh, you complete 1 year out there and then come back and give a representation after 1 year. When you
Hello,
have 1 year.
For 5 months, your lordship will certainly hold up, my lord. Because your lordship knows the problem, my lord, of the wife, more than me, my wife.
You submit a representation, let them consider. This representation is not going to help you right, left, and center. Why have you given this representation?
Yes, well, I've seen.
Yes, this representation doesn't say anything.
Doesn't say anything.
Then, don't have a case.
No, paragraph 1 is there. Paragraph 1, that doesn't say anything. That he is physically unwell. And one minor, my son is also there, my lord. So leaving his wife and my son here also is, my lord.
Hmm?
But there should be some, my lord, law is all right, my lord. But some change of compensation for the hey, should be also there, my lord. Change of compassion.
Law is law. You have to go
No,
as per
law,
law.
my lord, laws are for human beings, my lord.
You submit your representation, they will consider you join there and submit a representation. Better off.
My lord,
You join there and submit
my
a
lord, yes, my lord.
representation.
My
I
lord,
will
may I
get.
query one thing, my lord?
Lordship.
That is the
We'll
only thing,
submit the
Mr.
representation
Chairman.
by tomorrow, day after tomorrow. We'll submit the representation tomorrow, 8 by tomorrow, about day after tomorrow, or day after my close money by Friday.
You join
Join.
there, submit a representation, they will consider. Taking into account all this. Why should I consider? These are absolutely within the domain of administrative exigency.
There are other, my lord, there could be
I will
other.
say they will consider within 15 days. That's the only thing, nothing else. You join there. Thereafter, if they want, they will do it.
My lord, one thing I want to say, my lord. There are other junior officers also. They could also go to Jonai. Jonai extreme point, Mali also knows. Communication takes 2 days.
Huh?
Even by train, it takes almost 1 night and 1 day.
Is it?
Yes. You start from here, we reach Lakhimpur in the morning, then again from there to Jonai, Mokang Select. Last point. I've been traveling by train also. Here also knows I go throughout here, Assam.
Mr. Sharma,
Yeah.
from Lakhimpur to Hemaji, it is 54 kilometers.
No, 75 kilometers.
No,
Yes, mother.
54.
I have just
From Hemaji to Junai is 84 kilometers.
yes. 84 is all right, but here to my Lakhimpur to Jamaj is 75 mother. Anyway,
Okay.
150, total 150 kilometers in all.
150 kilometers is, and the roads are fantastic. There's very less of
Roads, my lord, now
communication.
this guy,
And nowadays you have the train, Mugan Select
Yes, that-
Express. So you, with that you can go there immediately, no problem. Or from here you take the Rajdhani out there in the evening and go and reach from there to, it is just 2 hours to
my lord,
Chennai.
6 months would not do make any difference, my lord.
Huh?
1 year is of course government consider. 6 months it will not make any difference.
Sorry, Mr. Sharma.
My lord, my lord,
No,
my
no,
lord,
no. This is not the case.
Okay, I will file representation. Let them
I am giving you a particular relief. Let me see what happens.
Yes.
Heard Mr. R.P. Sharma, the learned senior counsel, assisted by
Ankita Deka.
learned counsel for the petitioner. Mr. S.S. Roy appears
Okay.
on behalf of the respondent number 1, 2, and 3. This is the instant writ petition has been filed challenging the order dated 6th of June 2023, whereby the petitioner, who has been working in the office of the, what is DES?
Director
District,
of Economic and Statistics.
huh?
Directorate of Economic and Statistics.
Director in the office of the Directorate of Economic Statistics headquarters at Assam in Guwahati, was transferred as SDSO. What is that?
Sub-Divisional, my lord, Sub-Divisional Statistical
Officer.
Officer.
As Subdivisional Statistical Officer, Junai. A perusal of the writ petition shows that the petitioner is aggrieved by the order of transfer on account of the ailment of his wife and his children and his children who are presently pursuing their academics at Guwahati. Taking into account the scope of interference in a transfer matter being very limited, this court and limited and the reasons assigned in the writ petition assailing the writ petition, the transfer order, this court is of the opinion that the respondent authorities would be the best, would be in a position to decide as to whether the petitioner can be accommodated in some other place nearby, rather than transferring the petitioner from Guwahati to Junai. taking into account the above, this court is not inclined to interfere with the order dated 6th of June 2023. However, the petitioner would be at liberty to submit a representation before the authorities concerned, before the respondent number 2.
Yes.
Respondent number 2. And the respondent number 2 shall, on the basis of the materials placed, take a decision on the administrative exigency as to whether the petitioner can be retained at Guwahati or in a nearby locality, nearby district. With the above, the instant petition stands closed.
Obligation.
Yes, Mr. Counsel.
Well, this petitioner is hometown is Guwahati, but she's on some challenges, right? She donated her kidney, her ankle is fractured twice, and there is a plate, and also COVID infected patient. That is why there is some development in his heart, my lord. And when she was in deputation UDI 2 years back, she prayed for her posting, but it was not considered. Now, when general posting order is come out, a incumbents from Kerala, she was given the posting in Guwahati, and she was not considered, my lord. So there is a malified test also. I have projected this. So kindly see, my lord, this first order is page 26, 1721.
Which order you are challenging?
My lord, page 46 and 47, my lord.
You are challenging this,
Yes, my lord,
the
because
provisional promotion. Modification. Your name is what?
oh, my lord,
Lekkarani
this is a
Mazumdar.
general transfer order.
Huh?
General transfer order, rotational transfer, my lord, 11 March 23. Prior to that, I request them that when
Where is your name?
my name is not figured out, my representation or all my requests were turned down without any reason. And my lord, kindly see Deputy Rubber Production Commissioner in charge, that is my cadre, my lord. In this cadre, my lord, serial number 9, Radhamone Murikol. She was on request transferred from Guwahati to some other.
Where is the 11/3/2023 order?
My lord, page 47.
Huh?
Page 47.
47.
Yes, my lord. My request, if they consider my request, then they could have.
Where is your name? Not name. Your name is
That is why I am here before your lordship. My lord, in serial 14, page 48, kindly see. KM Saji, Regional Office, Manjeri. She was dragged and invited to join in the Regional Office, Guwahati. My lord, Vice Radha Moni Murikal. The 14/7 Radha Moni Murikal will leave Guwahati and she will join, my lord. So, my lord, I have annexed all these things, my lord, these medical challenges to me. I have served 33.
No, I understand, but how are you involved with this order?
My lord, because, my lord, kindly see page 46. Page 45, kindly see, there is acknowledgement of transfer request. My
The court
transfer
did not
request,
have consider her request for transfer to regional office Guwahati. From
Yes.
where? Where are you presently?
I am in Silchar, my lord.
So you want to come from Silchar to Guwahati?
Yes, posting in Guwahati. For last 2 years, I am submitting that because of my physical challenge.
What is your physical challenge?
My lord, kindly see, my lord, page page 31. I am donor of a kidney, so I am in one kidney. Then page 35, my lord. This diagnosis SP left, donor of nephrology, and
So why you can't stay at Silchar?
my lord,
It doesn't have a hospital.
because for reason, my lord,
Ah.
I am the donor of the kidney.
So?
Then, my lord, kindly see page 35, my lord. My left ankle, it was, my lord, broken in 3 pieces because of an accident, and now its plate is in my ankle, my lord.
Huh?
Plate, my lord.
Understood. So
So, my lord, there is a very difficulty in walking, my lord. Still, when I am given the posting in Silchar, I accepted it. And I am given assurance that when a post will vacant in Guwahati, I will be accommodated.
Where is it?
My lord, it is a oral assurance.
Oh, who gave it?
My lord, this department, because
Which department?
rubber boot, my lord.
Understood. Who gave you that? Tell me that if it is not on written, somebody has to
Yes,
give you. Who has given? Who has told you?
This petitioner told me that there is a post of DO, but I was given the in charge RPC. That is why I cannot accommodate as a DO in the regional office. And says that in 2023 there will be a post will be vacant. It was an oral assurance. I have not written, my lord.
You have not written also in the
Yeah.
petition?
Yes, my lord. Then, my lord, page 40, kindly see, my lord, there is a blockade in heart also. The scan thorax.
Then
Then my representation starts when page 41, my lord. It says that Guwahati is the medical hub of Northeast. So because my kidney transplantation, all these things, some medical treatment, frequently medical tests is to be done. From Silchar, one lady how can she come? Because 2 years left for my retirement. So at a home station with comfort of home and doctor's treatment, if post is vacant, I will be accommodated. My lord. The last vacant of my service.
but you went to Tejpur from Silchar to show your disease.
But Tezpur, my lord, there is some doctor, specialist doctor. That is why I was taken by a car, my lord, to Tezpur.
Then
Tezpur, my lord,
Tejpur
is
is nearer
a-
to Guwahati.
my lord, main thing, my lord, kindly see page
Mr.
45.
Borua, whatever may be, the challenge to this 11th March 2023, not
Challenge, not challenge, my lord. They have not, my lord.
we can do one
Hello.
best. No, Mr. Borua, this court can only do one thing, ask them to then instruction as to whether you can be accommodated somewhere so that it works.
My lord,
That is the only
this
thing.
is a order, my lord. Why I want to present their malafidness. My lord, in 2015, what happened? This petitioner is a proposal for deputation was approved, but still then they have not allowed her because of some malafide interest. That is reflected in this honorable court's order, my lord. I have annexed in 51, my lord. Page 51 annexure. This is the copy, my lord. Kindly see the last paragraph. This honorable court has observed that this arbitrary action was done against this petitioner because she approached this honorable court for some relief. The junior has given their this promotion. So that is maybe the reason why they are against it. Otherwise, a physically challenged person's, my lord, what is there? No exigency of service, my lord. A person from Kerala is same for Silchar or Guwahati, but she is definitely required. Well, kindly see last paragraph, my lord. That is her petition, my lord. Rashmi Rekha Majumdar. Last paragraph, the writ petition for going deputation. I find that the reason of rubber boat not to release the respondent.
Wait. I am also not convinced with the argument of the senior central government counsel to the effect that a respondent with petitioner service in Rababod is irrepressible due to her posting in her home state. Knowledge of what is this challenge? What did you make?
No, my lord. Kindly see last paragraph that honorable court has compelled to observe that there is some pressure from outside not to shift her from Guwahati, not to even join the deputation post also. RDO.
Well, at that point
That
of
is why
time, she
this
wants
is the
to,
arbitrary.
go on deputation. Ultimately, she went on deputation. She was on deputation.
Where?
She was on deputation at Guwahati under the UIDAI.
You are still at deputation?
No,
No.
well, let him finish. I'll make that.
My lord, what happened, my lord? From deputation, in one deputation, I was promoted. So I want to any post in Guwahati because in the meantime, I have some physical inability. So they said that your promotional post you join first, then we'll take. Then I have filed a representation that I may be accommodated Guwahati because 2 years is left for my service. And my lord, I am physically, some problem is there, some junior or others, maybe incumbent, maybe. That was not turned down, my lord. Page 46, they said I cannot do anything. And page 47, my lord, the general transfer order was, I am not figured out, my lord. Now, in July 14, that incumbents will join. The post is still vacant. So my humble prayer
You
is,
want to go to Kerala?
no, I am in Silchar, my
No, you want to go to Kerala?
lord.
Is it good?
Kerala is far away.
No, it is good, man. There are a lot of hospitals out there.
Well, they want me to go to Kerala because they are
Want to
against
go?
me. They are against me because
Yes, Mr.
No,
Nath. Huh?
but kindly see मतलब
You
the
want to take him to Kerala?
that if petitioner मतलब is ready, I'll have to take the instruction.
Petitioner wants to go to Kerala.
Kindly see मतलब.
No, if your health is the main question,
Correct,
Kerala is a very advanced stage on advanced state for
Well,
the
kindly,
purpose of
kindly
health.
see, Lord, she joined the rubber board on 1/3/1989, and since 89, all along at Guwahati or near to Guwahati.
in para 9, para 6, I have this diamond knock.
And
Well, Zonal office Guwahati she joined. Thereafter regional office at Guwahati, then again zonal office, then again regional office, then Nagaon under the regional office Guwahati, then Agia under regional office Guwahati, again Nagaon regional office Guwahati, then she went on deputation from 2015 to 22, 19th of June 2022. Then again thereafter मतलब, in the month of August she joined at the regional office Silchar. Well, kindly see page 41 is the representation of the petitioner. This representation was filed on 17/12/2021 when she was on deputation. Kindly see the third paragraph, third line of the first paragraph. Well, while in deputation going on, she said that I would be completing 7 years of deputation on
page that
Page-
I have suffered.
page 41.
Yes.
Page 41, first paragraph, third line.
Oh,
Logic.
Ah.
With due humility, so and so, I would be completing 7 years of deputation on 19th of June 2022 and subsequently repatriate to my parent department, that is rubber board. So, my lord, already she anticipated that I am going to complete it in next 6 months. So, in the month of December 2021, she filed a representation that you keep me at Guwahati. Well, finally, the next representation, kindly see, my lord, page 43. I'm just not reading the entire thing because her physical illness and all these things she has said. Page 43, kindly see. Although I have joined at regional office Silchar, I am facing certain difficulties since before joining in the month of December 2021, she is expressing difficulties. After joining in the on September 22, again she has filed similar kind of representation, and this has been considered, my lord, this has been considered at page 46. As per reference cited, Srimati Rashmi Rekha Mojumdar, Deputy Rubber Production Commissioner in charge, Regional Office Silchar is informed that the board is not in a position to consider her request for transfer to Regional Office at present. Well, kindly come to page 45. This is the application acknowledgement for transfer request. Here, kindly see, the tenure at present station is 5 months, 20 days. Before going to Silchar, she filed a representation before, in fact, completion of her deputation. Again, after joining Silchar, again she has filed an application. And because the 5 months, 20 days, at that particular stage, the authority said that at that stage, they are not in a position to consider her representation. Now, this order placing 11th of March 2023 is a order. She was no way connected. She is no way one of the agreed, should not be agreed. Again, she has filed a representation at
What is the present
49.
posting? Aru. She's Aru.
Deputy RPC in charge. Deputy RPC.
Deputy?
Deputy Rubber Production Commissioner.
What is this Aru then?
Regional
I'm the
office.
regional office.
Regional office. In charge regional office.
Regional office means Guwahati
We have-
regional office, Silchar regional office.
We have a regional office at Silchar. She's the in charge of that.
And the person at number 14 is regional officer.
Personal.
Yes,
uh,
Manjari, Kerala.
She is coming. She is coming
From
as
Kerala.
from Kerala. She is coming, my lord. And she has already been. My information said that she has already been relieved and she gets some time to join from
My lord,
Kerala and Guwahati. Within
without
that, my lord, she will
completing
join.
2 years, my lord, she cannot release, but she may take leave. But here it is written, page 48, my lord. The transferee from any other should complete the effective tenure. That is the 2 years, my lord. So before 1/7, she may not be released. She may take a leave.
No, she has been relieved. I'm told she has been relieved. But what?
And my lord, to which place, vice, she will be released on 14. 14 will be vacant, my lord, 14 July. So still it is vacant. There is no doubt about that. And
But what at this stage, kindly similar page 49, again, she has filed a representation. This petitioner has filed a representation on 1/5/2023. Well, my information says that at regional office Agia, a post is going to be vacant in the month of August on superannuation. This representation is pending before the authority. They can consider this representation subject to availability of that vacancy in the month of August. That much from their side they can do.
How far is Agia from here?
Agia, she has already served.
I have served. My lord, my only
Agia regional office from 97 to 2008. And in fact, in her representation, she
No,
said,
where is Agia?
Agia is
Gwalpara, my lord.
Boko,
130 kilometers.
Boko,
Gwalpara, then
after
Agia, then
Boko, it is
130 or 40. 130 or 40. Gwalpara
Yes.
is 120 kilometers.
Yes,
20 kilometers.
maybe 100. Agia, Guwahati to Agia. Distance.
My lord, here I have also taken instruction is that if she cannot stay in Guwahati for medical treatment, she will resign or voluntary retirement. This is her last chance for this court. Why their malafidness is because they are against this
130
petitioner, because
It
she
is
is in the
130
legal battle with this department for her legal
No.
rights. And in that order also, this honorable court is reflected that there is a tremendous pressure on rubber boat to shift him from Guwahati, because she always come to Guwahati for her legal right, and she becomes senior. Many will be affected.
Well, these things
That is
are
why it is
absolutely,
honorable
absolutely,
court's order.
absolutely.
Observation, my lord.
Well, I am not submitting anything on 2015 order, that earlier order. But these things are absolutely not correct. These are not absolutely baseless. At this stage, she has joined at Silchar, regional office Silchar. She is serving there. Only she at that point of time she has completed 5 months. Now, my lord, there is no vacancy as on today to consider her representation. My lord, this petition has been filed by the petitioner only for consideration of her representation only on health ground. My lord, she can take leave, she can go for with PRS. It is her own decision. But as on today, there is no such ground that the 11/3 to 2023 order at page 47 is to be interfered by this honorable court because of her.
No, unless, because the moment I interfere, you have to make everybody party.
Correct, my lord.
What do you
I
say?
make the respondent number 5 party. Respondent, private respondent, I make party.
Whom?
Who is this M. Saji, who is supposed to join the vacant post of regional office.
So then I thought that person concerned that you are alleging malafide against whom?
Against this, my submission is that they can easily accommodate me because there is a vacant post in Agia from Kerala, incumbents from Kerala, they may be accommodated. There is no balance of convenience or is in favor of me because of physical challenge.
Much liberty
there
may
is
be
no
given to the
exigency.
authority. Otherwise, how the administrative function will.
They overcome my difficulty only because they are against people, nothing else.
It is.
And, there is a judgment I want to rely, because when there's 24 months or 20 months is left for retirement, he may be considered for a hometown, my lord. And as per DOPT rules, a DOPT is governed by the service condition of the government. So it's also this aspect to be considered. I am, my lord, I cannot work properly, my lord. And every time a kidney problem is there. This is my lord, tribunal's order, my lord. Whatever may be.
Heard Mr. M.J. Borua, the learned counsel, appearing on behalf of the petitioner. Mr. Dinath appears on behalf of the respondent number 2, 3,
and 4.
and 4. Mr. H. Gupta appears for respondent number 1. Issue notice making it written. Where can you get your instruction?
Not telephonic instructions. I
No,
have, Lordship,
Put it on affidavit.
Sure.
We'll have it on 28th of July.
Lordship.
To notice making it returnable on 28th of July, 2023. As the respondent numbers 1 to 4 are duly represented, extra copies of the writ petition be served upon the learned counsel representing the said respondents by 30/6/2023. As regards the respondent number 5, steps be taken by way of registered as well as usual.
To regional office, I made a prayer, my lord, to his last, to regional office also.
Why?
To regional office, Guwahati, my lord, taken also, if your lordship allow.
No. Take it. Okay, you want an additional one, you can do it.
Yeah.
And so appears on behalf of the steps upon the respondent number 5 by way of registered as well as usual by 30/6/2023. Further to that, the petitioner is also given the liberty to serve an extra copy of the writ petition upon Mr. Dina so that he can transmit the said copy to the regional office, Guwahati, to the respondent number 5. The instant writ petition has been filed challenging the inaction on the part of the respondent authorities to consider the case of the petitioner from being posted at Guwahati. The petitioner also have assailed the office memorandum dated 11/3/2023, whereby the respondent number 5 would at serial number 14 have been transferred from Manjeri to Guwahati. It is the specific case of the petitioner that the petitioner ought to have been accommodated instead of the respondent number 5 in the said post, which the respondent authorities have not done so.
Considering his
The reasons assigned in the writ petition, in the opinion of this court, is not the reasons challenging the order dated 11/3/2023 in the opinion of the grounds on which the order dated 11/3/2023 has been assailed in the opinion of this court does not entitle the petitioner for the interim prayer as has been sought. However, this court directs the respondent, more particularly the rubber board, to file the affidavits on or before 26/7/2023, stating the reason as to why the petitioner's case have not been considered.
my lord, if she joins the infectious, my lord, so some protection may be given till then, my lord, then I will try and track in next step, my lord. Otherwise, my lord, she will join, it become your post will not be taken.
I have already rejected.
Rejected, my lord. Actually, my lord, last 2 years is there.
39.
It is dismissed by appeal.
Yes, madam. Earlier you filed some similar matter.
My lord, this is regarding my lord's family pension and other service benefits of the petitioner's deceased husband, my lord. The petitioner's husband had been placed under suspension on 24/5/2003, my lord. Subsequently, my lord, during suspension period, my lord, he retired from service on 31st of December 2012. And thereafter on 16/10/2019, he died, my lord. So, my lord, till his death, my lord, he was receiving sufficient allowance, my lord. And the detail is at page 19.
He was receiving subsistence allowance.
The petitioner's husband, my lord.
Was receiving.
Yeah.
Okay.
Till
What-
his death, my lord.
What happened? What happened to
Yeah.
there was any departmental
No,
proceedings
no.
or criminal proceeding?
Nothing, my lord.
Why was he suspended?
On a criminal charge, my lord, annexure A, my lord, FIR is annexure A page.
What happened to the FIR? DR 22 means it has must have been charge sheeted.
Yes, my lord. It was
What happened?
Charge sheeted, my lord.
Then
but
what
it,
happened?
My lord, convicted, lord. Sir.
Huh?
It convicted.
He was convicted.
Convicted.
Then
Appeal was pending as
before going to jail. Then what happened?
no department of proceedings. ma'am.
After your conviction, what happened?
My lord, the petitioner was receiving subsistence allowance.
Understood, but you were convicted.
Regarding, my lord, the criminal.
You are not aware.
My lord, no, my lord, the author has been.
Madam, she was convicted.
My lord,
as
he
per
filed
your,
a appeal before
Ah.
this honorable court.
Where?
Page 20 annexure D, my lord.
In page
During pendency of the appeal, he died. Page
Page
20, my lord.
20,
Yes,
annexure
lord.
D, General Counsel for the man didn't die. Okay, then,
My
so your
lord, the-
conviction remains.
yes, my lord, but the petitioner. he
If
is
your
a widow.
conviction remains, can you get your salary or
But my
pension?
lord, your lordship, I have quoted one provision, my lord,
Ah.
of FR 54B2, my lord.
Ah.
Here, may I read, my lord?
Yes.
Notwithstanding anything contained in Rule 53, where a government servant under suspension dies before the disciplinary or the court proceedings instituted against him are concluded, the period between the date of suspension and the date of death shall be treated as on duty for all purposes, and his family shall be paid the full pay and allowance for that period to which he would have been entitled had he not been suspended, subject to adjustment in respect of subsistence allowance already paid. My lord, if it is convicted also, my lord, his wife will get, my lord, the subsistence allowance as well as the, my lord, other family pension as well as other service benefits of the petitioner.
If you are convicted, how
entitled.
can you get it? The conviction stays.
But my lord, the appeal was pending before this honorable court.
Understood, but the appeal has been dismissed as abated.
Yes,
but
my
your
lord, because
conviction
during
remains.
pendency, he died, my lord.
So the appeal should have been continued out there. You should have continued
Appeal
this
is not
appeal
done,
through
yes,
here
my
for
lord.
the purpose of the pensionary benefits. That is normally done. You have not done that.
But it was not done, my lord.
Huh? Then,
It is submitted
but
representation.
under what provision he was convicted?
304, 302, my lord.
How can it be 302 and taken up by a single bench?
304, lord.
304. That is what?
Paragraph 4
Of?
of the repetition, lord.
Hello, anyways, we issue notice.
Lord, yes, my lord.
Heard Ms. S.P. Chaudhary, the learned counsel appearing on behalf of the petitioner. Ms. R.T.B. appears on behalf of the respondent, all the respondents. Also, issue notice making it returnable by 16th of August 2023. As the respondents are duly represented by Ms. R.T.B., extra copies of the writ petition be furnished by 36/2023. The case of the petitioner herein is that the petitioner, the husband of the petitioner, was working in the, was an employee of the NF Railway. Full stop. Upon being arrested in connection with a criminal case, the husband of the petitioner was suspended with effect from 24/5/2003. Full stop. It has been alleged in the writ petition that the petitioner's husband retired from service on 31/12/2012. However, the suspension period was continued against the husband who expired on 16/10/2019. In the criminal proceedings which was initiated against the husband, The Court of the Learned Additional Sessions Judge number 1 Kamrup at Guwahati in Sessions Case number 390/2010 convicted the petitioner under section 304 part 2 by the judgment and order dated 28/9/2015. It further appears from the records that the petitioner had filed an appeal, being criminal appeal number 43/2019, which was pending before this court. Filed appeal, which was criminal appeal number 43/2019 before this court. It is relevant to take note of that during the pendency of the said appeal, the husband of the petitioner expired, and as such the appeal was dismissed as abated. It is the case of the petitioner herein is that the petitioner would be entitled to the pension and other pension area salaries of the petitioner. The learned counsel appearing on behalf of the respondent, and it is on the entitled to the pension as well as the area salary. It is in that premises the instant petition has been filed. The respondent shall file the affidavit. Look at your next date, 16, no? On or before 11th of August 2023.
And number 12 to 25 permission.
Yes.
I'm submitting a paper book lordship.
What is this paper book business?
All the judgments and other things, but lordship giving single papers. All the notification also I have compiled in the paper book.
Yes. No. Only thing is, yes, Mr. Gogoi, on the last occasion I put you a question.
Well, what the
Did you get hold of Mr. Kyle? No, when you are giving an exemption
Well.
by way of a notification,
Well,
meaning thereby you can't exempt anything which is not there.
that power will have to be there,
So it has to be subsumed. Without subsuming it, the question of
exemption.
exemption does not arise.
Well,
The same is also the effect as regards the central government. The central government also has exempted the CGST.
lordship.
Now, why I'm worried? Otherwise not. Now they stopped. After something must have happened, they have stopped. When did you stop?
After 12/6/2020.
12?
12/6/2020.
That's it.
Why did you
7.
stop it?
Because the central government not ordinance.
Central government notice, but otherwise he should have stopped it from 1/7/2017.
Yes, that
Because from that time, the GST
GST came in
notification has come in. So he couldn't have charged anything to the effect.
exemption.
Yes,
But there is an order from the government of Assam, the Agriculture Department, dated 31st July 2017,
where is
What?
it?
in my affidavit, Lordship,
What does it say?
that with reference to the government notification issued by the Finance Taxation Department, you are directed to withdraw the segregates under the establishment of Assam State Irrigation Marketing Board with effect from the midnight of 31st July 2017. However, normal realization of the cess under section 21 of Assam Irrigation Produce Market Act 1972 on specified irrigation commodities from market area will continue. Lordship. They have not challenged it till now. This order.
They may say all the, but on the other hand, they give an exemption. I refer to a judgment, Mr. Gugoi, last time. I gave you a
Mafatlal.
judgment.
Mafatlal bhai.
No. The other one, what is that, 2004 or 14, I forgot. Yes, I gave it to you. Your-
PK re-rolling,
Huh?
PK re-rolling mix. Private.
Where is that, 2004 or 14 something, where is it?
Document 264, it is, the reference is,
2007. What does it say?
it says that, Lordship, it's 2007 4 XCC 30.
Yes.
That's it.
What does it say?
At its-
264.
Page 264.
264. Sales tax exemption, levy, distinction, head, liability of tax.
But absence of collection does not mean absence of liability.
Huh?
Absence of collection does not mean absence of liability, and absence of levy does not mean absence of Lordship, collection does not mean absence of levy.
Where are you reading?
Lordship, this is from the head note itself.
No, don't read from head note.
Yes, Lordship.
Head note is
It's here, Lordship.
everybody mixed. You read the head notes of some of the journals out there, you will be shocked. Yeah, which paragraph?
Lordship,
Impact of exemption on liability to tax. The first aspect of the argument, paragraph 22.
yes, Lordship, 22.
The argument of the respondent is that with respect to the effect of exemption upon liability. In our opinion, exemption can only operate when there is a valid levy. If there was no levy at all, there would be nothing to exempt. Mr. Gugoi, this is the paragraph.
Yes.
You have not looked into it, in spite of the fact that I have given it to you,
Yes.
thinking that when I am not sitting in this bench, this matter has gone out and as such not required to read.
It bounced back again, man.
Huh?
It bounced back again, man.
It has. That day I gave it to you.
Yes, my lord. That I wrote in a piece of paper, my lord, I was mentioning it.
Sir, you can't exempt something which is you don't have the power to levy.
Lordship,
The moment you have exempted, means you have the power to levy.
Lordship,
And power to levy means the power was there in the GST.
Lordship. Same is the case in case of VAT, my lord. Section 54 empowers us to, my lord, give exemption, like in the policies, industrial policies and all. So whether that power is there in the GST or not, my lord, that part, of course.
Obviously it is there. Otherwise, why will it be a
Yes.
GST account? The power will handle, and in fact, that notification must have stated that.
Yeah.
Why do you need to look into all this?
Yes.
Where is that notification? Yeah.
It is CST, madam. Presently, CST is not there. It is integrated.
No. One is by the central government, one is by the state government. See section 11(1). Power to grant exemption from tax, section 11(1) of the CGST Act. And where is the state?
State, madam, state, section 11.
Huh?
Section 11. State.
It is in fact a repetition of
Yes,
that
yes.
only.
Yeah.
So this power has been exercised.
Yes.
And the power can only be exercised if you have the power to levy. So that means it was there in the CGST
Lordship.
or the GST. So that issue is solved,
Yes.
nothing else. Now comes the question of refund. Yes, what do you say on refund? Where is your statement that you have not passed on?
Lordship, I have made statements. Petition, I have filed an additional affidavit showing that Lordship, actually this, Lordship, these are agriculture produce which has been, Lordship, the amount is fixed by the government. It cannot be passed on because the amount, if I cannot sell it beyond 10, whether I collect agriculture cess or not, with beyond 10 rupees, I cannot sell. If they have fixed, because the government fixes the prices, Lordship. This agriculture produces the Lordship. We cannot, atta, maida, fuji and all. Lordship, these are government regulated things. So we cannot sell it beyond a certain price. So Lordship, as it says, we cannot collect it from the customers. We cannot take the amount from the customers. We have Lordship made specific plea because they have already taken it from me at the check gate, saying that okay, you will be taking it. In the future you are going to sell it, so we will charge cess from you in advance. This is what they have said. And Lordship, I have annexed all the papers and documents in their petition. And Lordship, whatever it is, Lordship, now whatever amount is being collected by them, it's an illegal levy. And Lordship, my specific statement is that I have not collected it from the customer and I could not have because my amount is fixed. I cannot sell it beyond a certain price. I cannot charge it from the customers.
What did you bring?
Lordship, atta, maida, suji, coconut oil, all these things. Lordship, the price is fixed.
It's fixed where?
Lordship, some are government regulated, some are Lordship, the MRP is fixed. Lordship, I cannot charge it beyond the price which has been mentioned in
MRP for what?
Lordship, that coconut oil which I bring from the outside state of, I cannot charge anything beyond the amount.
Now, how do you bring the coconut oil?
Lordship,
Is it in parachute?
Yeah.
Parachute, Lordship, parachute coconut oil.
That
other things.
product, madam.
Product.
MRP is there, madam.
MRP is there, Lordship. I cannot.
No, well, how can that be? How can you impose cess on that? That is not an agriculture produced.
See, we only put, collect cess, only.
No, if it is are you going to do tomorrow to Horlicks also?
No, we have to, Lordship, kindly see what is the case, Lordship. They are, in this case, they are paying Lordship, wheat and masoor dal and chana.
And not coconut oil, not in there, obviously. So that is loose.
Loose, sir.
They bring it out there most probably in the sacks.
Yes.
Or bag, jute bags.
Good.
Then that is a different question from selling a parachute oil type. Or a coconut oil in a big tin. It's a that's a different thing.
Well,
There cannot be an MRP for these. How can you say there be an MRP for masoor dal?
No,
Then-
Lordship,
or wheat?
Lordship, for wheat, there's no, because they are government regulated, Lordship, and so there are some products.
And does the government fix a rate on the sale of wheat? Huh, Mr. Gugoi?
no.
No, I've never heard that.
There cannot be a fixed rate, madam.
They said something in the government during the COVID, it's a different thing.
Sure.
Otherwise, no. Then, is this the period during COVID? No, COVID was not there. So, where is the question of it's fixed?
37%, they stopped taking only.
Huh?
From 37, 2020, during the COVID, they stopped taking the,
Then,
because because of they have now.
yes, what do you want to do?
Lordship, we collect the cess on the schedule items. It is the
Ah.
schedule.
I've that book. Wait.
That's it.
On the last
Yeah.
occasion, the learned coordinate bench was very kind enough to get this book for me.
Page 70, Lordship.
Page
70.
70.
But they are taking Lordship says on coconut oil also. My case is there in the before. your
Coconut
Lordship.
oil, are you saying the coconut must be in teens,
Lordship,
in big teens,
Marigold
jargons? Then,
Lordship, that case is also there. Marigold
is, huh?
your Lordship. That case is
Page
also there
70,
for your
Lordship.
Lordship.
Page 70, yes, what you are taking on jute,
Jute
Jute,
is there.
cotton, mesta, petty, rice, muri, sira, pie, wheat.
Wheat and wheat products, Lordship.
You are getting what?
Wheat and wheat products, Lordship, are there. Lordship, then I bring rice also. I bring pulses, Lordship, pulses are there. Matti kalai, matti mala.
But how are you saying that these are fixed rates?
Some are fixed rates, some are.
Where is the fixed rate? Show me which document you are saying. Show me a document on which you are saying that these are fixed rates
But
by
these
the
are not
government.
fixed rates. These are not fixed rates.
No.
Some are.
Huh?
Some of them.
No,
are.
which one? Show me someone.
Then there are fruits, vegetables, oil seeds are there, lordship. mustard
Vegetables,
oil
are you
is
going to
there,
say that there is a MRP fixed by them?
narcotics, lordship is there, tobacco, then fruits are there.
You get fruits also.
No, I will
Yeah.
not bring fruits.
We are only concerned with which other items we are concerned with.
Lordship, there are some pulses cereals. My products falls basically under 2 and 3.
Huh?
Which is there, item number six, schedule
3
six,
and 4.
Schedule?
schedule
Item-
six,
Item number 6 in the. schedule.
Item number 6,
in the schedule,
the fruits,
not it.
they get fruits.
No,
No,
lordship,
lordship.
we don't bring fruits into the state.
Schedule,
Lordship, we basically bring fruits.
WBC one.
let one person
With
speak.
masoor dal and chana.
Where do I get it? Wheat bran polish?
Yes, Lordship. The serial number 2, Lordship, 2.
Serial number 2 is cereals
Yes, your
Serial,
lordship.
and 3 is pulses.
Pulses.
And then
3, 4 is oil seeds, lordship.
you get oil seeds also.
Lordship.
Oil seeds, sesame, oil,
masoor.
oil.
In
This is
pulses,
oil seed,
Oil seeds, lordship, what happens, lordship?
not
if-
oil.
Lordship, I bring, lordship, if we get mustard oil also.
Yeah, sir, ma'am.
Mustard oil also we get.
Where yeah, mustard oil is, oh yes, mustard is there.
Mustard is there, lordship, mustard oil is not there, but
Hmm.
they treat it seems it is a oil seed, mustard is there.
Mustard.
They treat mustard oil also as a commodity. Lordship, there is a judgment of this honorable court in regarding mustard, but I am not onto that.
No, but
This-
tell me, how are you saying that you have not passed on? And you have not done it, that is a wrong thing if you have not done it, but how do you say that there was a fixed rate to that effect?
No,
In some of the-
Yes,
Burden has
Mr.
been-
Gogoi,
Probably-
where do you want that money to go?
Full melody, it will remain in the state exchequer.
Obviously, no,
At least for some funding,
Lordship,
they can't have it.
they can have it, madam, yes.
So where should this money go?
That Lordship will be the best person to.
No, I am not. You are the finance. We should give it to the TNRT, I suppose.
Flood is going on, my lord, must go to the flood relief. Part.
Lordship, as per Mafatlan Industries, Lordship, this should stay with us.
Huh.
As per the judgment of
No, no.
Mafatlan Industries 9 judges bench.
Yes,
On
what
this
does it say?
The Supreme Court, Lordship. I have, Lordship, I next that judgment at page 155. of my paper book. Page 155, Lordship.
You're going to take it at the board. Let me come back in 5 minutes, huh?
Yes. हम लोग का एंट्री मॉडल बोलता कि नहीं हम लोग एंट्री मॉडल विकल्प नहीं करता एंट्री मॉडल हम लोग ऑलरेडी दिया गया कि कलेक्ट करते रहो और ना
I'm going to defer.
इसका कॉपी का
Yeah, something.
एक को भेजा Lordship, before coming to Mafat Lordship, I would like to just Lordship point out the interim order which was passed in this case, Lordship, this case itself. Lordship, in the interim order, Lordship, I don't have a copy of that. In the last paragraph, last paragraph, Lordship, it was specifically made sure that it is however made clear that if the respondent board collects cess in connection with the prison of petitioner, respondent board authorities shall be liable to refund such cess collected from the petitioner during the pendency of the writ.
The interim order is however not final for the purpose. We have to go as per the law
Yes.
statute.
Lordship, only for the purpose that. Lordship, page 155 is a 9 judges judgment. 1997,
155.
1997, 5 HCC 536.
I also gave another one now. What is that judgment? That day I gave it to your junior. What was that?
Corporation. Your Lordship, State of Maharashtra versus Swaston Multiplex Cinema. That
Where?
is page 142.
Page 140.
Two.
Yeah.
2009 8 SNC 235.
Yeah.
Lordship, over here it has been held that some portion will be given. to the-
Here, Mafatlal has been taken note of.
Yes, Your Lordship.
A claim for refund whether made under the provisions of this act as contemplated in proposition 1 or 2 above can succeed only if the plaintiff petitioner alleges and establishes that he has not passed on the burden of duty to another person or other person. His refund claim can be allowed decreed only when he establishes that he is not passed on the burden of the burden. It is neither an absolute right nor an unconditional obligation, but it is subject to above requirement as explained in the body of the judgment. Where the burden of the duty has been passed on, the claimant cannot say that he has suffered any real loss or prejudice. The real loss or prejudice is suffered in such a case by the person who has ultimately borne the burden, and it is only that person who can legitimately claim its refund. But where such person does not come forward or where it is not possible to refund the amount to him for one or the other reason, it is just and appropriate that the amount be retained by the state, that is by the people. There is no immorality or impropriety above the proposition. Now what has happened? We therefore direct that the state shall realize the amount to the extent the respondent have unjustly enriched itself and pay the same to a voluntary or a charitable organization. Yes. According to it, is a reputed civil society organization and has been rendering good service to any section of disadvantaged people and in particular. This is the best way. If we ask other people, the last line is very relevant. Have you seen that judgment?
Yes, sir.
See the last line at paragraph 29.
Yes.
He would be the main person who can take that.
My lord, yes.
Huh?
That's
He
why I
can
said, my
enforce.
lord, in the relief part.
He can only enforce it from getting that money from.
Right.
Otherwise, it will be very difficult.
Right.
Responsibility, if we give it to him,
My lord.
then he can put it in the best thing.
Regarding refund of has already settled in the judgment of Tinsukia trading of it.
What does it say?
Says that as regards to the refund of the cess already collected, we would like to say that since cess has already been realized by the authorities, the same need not be refunded. This is the observation.
Lordship, this is talking
that
about
instead it is.
2001 judgment. 2001 judgment. Lordship.
Then also you have been doing all this. And more particularly after the GST had come. You couldn't have done that. After that, you couldn't have done. Go to the state to retain it, not you. You can't be enriched. That judgment is a different judgment on syndicate trading at that point of time.
2001.
Then you that has Mafatlal taken into consideration that judgment?
No.
Then it's a 9 judges bench.
There is another judgment of Meghalaya High Court very recently, division 10 judgment, which has Lordship, I have next the judgment at page 8. Lordship, it has what he has done is that 20% of the amount realized has been given to the individual petitioners. Page 8, Lordship, I have a next.
8,
8, Lordship.
8.
8 of the paper book. Page 14 is the relevant. Or page 13, last paragraph. Page 13, last paragraph, page 50. But it was almost
Cannot
similar
be
item.
stated with a
Similar
degree of
case.
as to whether the illegal levy amounted to specific percentage of loss. But just like
Page paragraph 15. It's 13 paragraph.
No, here the state had done.
Get it.
Here it is not that done by the agricultural board. Therefore, let the state decide and do it. We will ask you have to file an affidavit also. I think the best judgment is that judgment only I gave it.
Yes, sir.
Let these people decide on this, how it is to be done. This is a custom multiplex. This judgment is more relevant.
But in fact, in the Patla judgment, at paragraph 238, 240, 241, somewhere the court has also said that because the persons cannot, how will you return to the persons? The persons are not recognizable at page 246. Because the persons to whom, even if I have collected, collected from the person, you cannot recognize them. It is not possible to get a one-to-one relationship with them and then find them out and return the money to them.
Now, that is what has also been stated out there in number 3. Where is it?
Page 246. Para 240, 238 and 240 is the main paragraph. Lord. Page 246, paragraph 240.
The creature of the statute is power. This is not on the question of unjust enrichment, which portion it has been taken, 200, and that has been noted here, na?
238. Lordship, this is the judgment. Lordship, there are actually 9 judges. So every judge has given a different judgment. Lordship. This
Now
is-
we are concerned with the main one.
Yes, Lordship. This order was passed by Kandya.
By
This was passed by Mr. Justice S.C. Sen.
in
It started from page 225.
paragraph.
SC Sen started from page 225. From paragraph 153 it started. And at page 246, at paragraph 238, 240 and 241, it is started from page 225, Lord. Justice S.C. Sen.
Now, which is the
Lordship, the 5 judge, because Lordship, the 4 judges has given different judgment. 5
how-
judges has
now
given
how was this
129.
judgment delivered? Justice P.P. Reddy was the one. I think
Yes,
his was the majority.
He was with the majority. Lordship, 5 judges were with him. Thereafter, Justice A.H. Ahmadi dissented from page 194. Started from page 194, the dissenting judgments. Till page 193, 5 judges.
Yes.
Till page 193, the judgments are there of 5 judges.
This 71 paragraph.
Yes.
179.
Yes, yes.
This is how it has been stated.
If the final paragraph is page 100, paragraph 100 at page 193. Thereafter, Lordship, the dissenting judgments have started. from
Whether
page-
is section 11 bad device for illegal entry from respectfully.
Page 193, paragraph 100.
Where?
Page 193, para 100 is the Lordship, the final judgment of 5 judges, Lordship.
Para 99,
Page 193, para 100.
190.
3.
The discussion in the judgment yields the following proposition. We forewarn that these propositions are set out merely for the sake of convenience. Reference are not supposed to be adopted. The refund of duty is claimed on the ground that it has been rejected from the benefit.
From page number 94, Lordship, the dissentings have started.
Claim for refund number 3, 191, Roman 3. A claim for refund whether made under the provisions the doctrine of unjust punishment is just and salutary. No person can seek to collect the duty from both ends. In other words, you cannot collect the duty from his purchaser at one and also collect the same from the state on the ground that it has been collected from him. The power of the court is not meant to be exercised for unjustly enriching. The doctrine of unjust enrichment is, however, incapable to the state. The state represents the people of the country. No one can speak for the people being unjustly enriched. It's not open to any person to make a refund claim to the people of the court rendered in the case of other person. It cannot also the meaning of it, but the mistake. Mr. Gogoi, I post this matter on 36, on which date you ask your people and tell me where should this money go?
But it's at some amount come to
Why?
20%.
Why?
Lordship, because I have not really passed on the burden. My invoices shows it that I have not passed the burden to the other
That is
person.
impossible. This vote is not going to be.
businessman, they won't be sitting with it.
No. That amount you can't. Then you do one thing, withdraw the suit and withdraw the petition, file a civil suit. That you do. It is nothing to do with it. Because here you see, category, the power of the court is not meant to be exercised for unjustly enriching a person. The doctrine of unjust enrichment is, however, incapable to the state. If they have done illegally, this money shouldn't be there with them. Money should go to some other paper place. Heard Ms. N. Havalier, the learned counsel appearing on behalf of the petitioner in the instant batch of this petition. Mr. B. Gogoi appears on behalf of the Finance Department. Mr. N.J. Gogoi appears on behalf of the Assam State Agricultural Marketing Board. The hearing is complete. During the course of the hearing, one additional aspect has as a reason as to if this to the effect as to whether as to the effect if this court is of the opinion that the petitioner herein is not entitled to the refund of the amount illegally collected by the Assam State Agricultural Marketing Board. Then in that circumstance where the money no, then in that circumstance where the money, where the amount illegally collected should be directed to be paid. Taking into account the judgment of the Supreme Court in the case of the state of Maharashtra and others versus Boston Multiplex Cinema Bracket P Limited reported in 2009 8 SCC 235. Mr. B. Gogoi, the learned counsel for the Finance Department, shall apprise this court on 13/6/2023 in that regard. List accordingly.
Only
Can
one
I have
thing-
a copy of this order, madam? Immediately I will convey.
A copy of the instant order be furnished by the court master of this court to Mr. B. Gogoi to obtain the necessary instructions in that regard.
Alright.
He can provide you with it. Joint Commissioner, এখন ভরাই এখন ভয় এখন বেলেগ get for all that luggage. You ঘুরাই দিব কি deputation state rubber board কিছু হয়ে গেল
But if, only one submission I wanted to with the 21A was inserted. Section 21A under the Assam Agriculture Cess was inserted. So after the judgment of sincere trading, that check gates will be established all over the state of Assam. That was done away after coming into effect of GST. So that has that may kindly be considered. That was lordship removed after the coming into effect of GST. Still they were
that
collecting.
the government has also issued the letter to
Yes,
the
Your
effect.
Lordship. That's okay.
26.
The lordship. The petitioners.
Yes, Mr. Doctor.
The petitioners were are working in the grade 4 post matter in the water resources department. Actually, there petitioner one is a boatman and other is a sweeper. But their basic cases, they have been now being paid a salary of rupees 2,000 per month.
Oh.
That too, my lord, admittedly, my lord, 1,65,000 on odd areas for the my lord, year
So this
2018.
will is in the case of Upenda.
Upendas, my lord, and my lord. Water resources.
Water resources is there by the finances to support you.
My itinerary will take.
You have been working for the before 86, how many years?
My lord, from one is from 89, my lord. Now one is from 1902, one is from 2002, and one is from 2006, my lord.
Petitioner is number one is from 89. Petitioner number 2 joined Miller in 92, Miller.
Hmm.
Petition number 3 in 2002. And the petition number 4 on 1/10/2006.
So your case is why you should not be similarly given similar relief.
Or Miller, they are saying that we are part-time workers, Miller. They are not. They are trying to say we are part-time workers. Though we are saying, Miller, that our duties are similar to those who are regularly appointed. Miller, in that event, Miller, if even if not the scale, Miller, at least the minimum wages should be paid to us, Miller. That Miller, because otherwise, the Miller, the lottery will see only 2,000 rupees per month, and that too, Miller, is not being paid regularly. Admittedly, Miller, more than 1,65,000 area has not been paid, Miller. That is an admitted position. That's for the period 2018, 19, 19, 20, and 2020, 21. Even that, there is also not being paid to them regularly.
A part-time worker is not a valid, even if it has not been reflected in the Jagdish Singh's case also. But
Yes.
it will be difficult.
They are part-time.
No, they have admitted, Miller, they are
No,
part-time.
no, our case is that, Miller, the job we are performing is full-time, Miller. So, in fact, Miller, appointment letter of petition number 1, Miller, in 1989, that doesn't refer to as a part-time appointment, Miller. It refers to only says whether fixed pay appointment. Of course,
Where?
with regard to the others, the appointment letters are saying part-time.
These are
appointment.
master role. Annexure 4.
Annexure 1, Miller, Lordship will see, Miller,
Who are these people? What are you there at Annexure 4?
Yes, Miller, these are all the petitioners, Miller, different petitioners. Miller.
Annexure 4?
Annexure 4, Miller, is one of the petitioner, Miller. He's a boatman, Miller. Lordship will see Miller's initial appointment at page 89, Miller. Sorry, Annexure 1, Miller.
Now page 18, 20,
Yes, Miller.
your names are there.
Yes, Miller. No, Miller, it's on one of them. Miller. The petitioner 1, Miller. Abdul Motin Borbe, the boatman. Miller, this annexure 1 to 4 are related to his appointment. Miller. Then there are other appointments with regard to the other person. 1 to 4 and 1, 4 and 5, 1 to 5, Miller. Then Miller. No, in fact, there are more, Miller.
What do you do?
One is a petitioner 1 is a boatman, Miller. Miller, he is employed for Miller various Miller survey Miller measures, Miller. He's given different kind of posting Miller to find out water level, Miller, for survey of water level, etc.
Yes, Mr. Kustami.
Yes, they are all part-time worker, my lord. In fact, otherwise there is no problem in giving the benefit out of the judgment of this honorable court, my lord. That is the problem, my lord. And in this regard, may I submit one thing, my lord. The petitioner may submit a detailed representation to the authority. Affidavit, which we have filed, my lord, in our affidavit, we have categorically stated, my lord, that all our part-time workers, sweepers are there, my lord, boatman is there. The service of the boatman is also not regularly obtained by the authority, my lord. But since they are part-time workers, my lord, as and when their service is required, my lord.
But Mr. Kustami, kindly see page 20 of the petition.
My lord, yes. Yes, casual, the word casual, my lord.
No. Master role and casual employee
My
are
lord.
engaged in duty under
Yes,
the
yes.
control of so and
My
so.
lord. Other than the master role, my lord,
Ah.
these all are casual, my lord. All are casual.
No, but
But he is not a casual, my lord. Sorry,
in-
master role.
But in Upenda,
My lord.
if you see page paragraph number
Yes.
so and so, master role, work charge employees similarly not in thinking. Superior to the master role workers, work charge workers.
All
All
are-
work
yes.
charge workers and similarly placed employees.
Yes, absolutely, my lord.
Not in
Is large.
section 4.
Then whether they would not come under the casual.
Yes, that is the submission of, my lord, in this case, my lord, I'm making this submission, my lord. In fact, that judgment is not applicable in the instant case in view of the fact that they are not regularly working, my lord. They are part-time workers. That is the problem. Suppose sweeper, my lord, not in one place they are working, my lord. 1 hour here, 2 hours here, this type of work they are doing, my lord. Boatman is also in the same way. Otherwise, my lord, giving the benefit out of the judgment of this honorable court, there is no problem otherwise.
No, 1 hour here and 2 hours there means
My lord,
in-
part-time, my lord, sweepers like that.
understood a sweeper.
My lord.
1
And-
hour here and 2 hours in some other place, whether
Yes.
it is under the water source.
No. That is I am submitting.
And the boatman,
Boatman is also, my lord, the service of the boatman is not always required, my lord.
That the affidavit is not very clear, my lord. They are only saying that we are part-time, my lord. They are not saying that I work in different
He
places,
is
my lord.
annexure.
Same
itself
page 27,
speaks,
lot
my
will
lord.
see, my lord. The appointments are on consolidated pay per month, my lord. It's not, my lord, not as if, my lord, that while appointing, my lord, it was said that you will work for a particular day in the month and not like that. My lord, all the appointments were fixed.
No,
pay of
here you
15 per
are,
month.
kindly see paragraph number 5 and 6 of your affidavit in reply.
My reply, my lord.
Like, yes.
Your reply.
Yes, my lord. The fact remains that, my lord, that they are discharging full-time duties and have to discharge their duties, respective duties anytime.
But you are not denying that though there are references in some documents that the engagements are on part-time basis.
Yes, well, the appointment letters refer to us, that I cannot deny. That's a matter of fact.
Then if you are part-time, how can you?
But we will, the service which is being extracted, that's full time. That is what I'm saying. Even if it is part time, my lord, if the job is, my lord, full time, I'm discharging my duties for that day, my lord, then, my lord, it makes no sense, my lord, no difference, my lord. Ultimately, it's the work that I'm, my lord, performing. My lord.
But how can you get the minimum scale of pay for that if you are doing part-time?
Because, my lord, if I'm doing, my lord, as per Jagdish Singh, my lord, if I'm doing my lord, performing responsibilities, my lord, for the entire day, my lord, similar to others, my lord, then, my lord, I'm entitled, my lord. Whether it's the nomenclature says it's part-time appointment or temporary appointment, it makes no sense.
No. Jagdish Singh, if you go by that, Jagdish Singh says that those casual employees who are there
My lord.
working and doing all the work which are normally of the same grade are doing, then they should be given not the same pay scale, but a minimum of the scale of pay.
My case is, well, the sweeper is performing the duty of a sweeper or regular sweeper, my lord, all the same duties, my lord.
So that you have not denied to that effect.
No, that's what I'm saying, my lord. That's what I've said in paragraph 5.
No, kindly see at paragraph number 6 also, what
Yes,
you
sir.
have said, that the duties of the petitioner are similar.
Yes,
You are not saying say that no, it is not a part-time. We are doing full-time.
yes, my lord. Similar to those in regular and full-time employment. So what you are saying, my lord, is that we are doing similar duties.
It is a question of fact.
My lord, then, my lord, in that sense, that's what I'm saying, my lord. Perhaps they can, my lord, think of providing the minimum wages at least. The minimum wages at least, my lord, the government is providing. The minimum wages is at least 10,000, my lord, the 23 notification, 10,000 plus the non-skilled workers. The boatman has to be a skilled person, my lord. Not anyone can, my lord, run a boat in the river, my lord. So the others are non-skilled. Let us take the others as non-skilled, but petitioner one is a skilled employee. So, as per that, the minimum wages notification, at least 10,500, something 500 odd comes for the non-skilled, and the skilled is little higher. That's a 2023 notification. 2022 notification was modified, and 2023 notification, that is the position, method.
No, minimum wages you are claiming.
The semi-skilled, my lord, are 12,261, my lord, as per 23 notification, 27th April. And the unskilled.
Mr. Dr. It is only in respect to those scheduled industries, minimum wages will apply.
True.
Scheduled employment.
But here
Whether these are scheduled employments.
Here is a state, the model employment, at least they must follow what is providing for others.
This is a very difficult thing.
Look, they are recommending some for the private concerns, my lord. They are the model state, the employer, my lord. And they are, my lord, exploiting these people at 2,000 per month, my lord. That's the difficulty, my lord.
Very difficult. This is more difficult for this. Because that will only apply for scheduled employment.
Well, that's what I'm saying. Well, though it may, this is notification for scheduled employment. That's correct, but then fact remains the model, the state, my lord, which is dictating others that you pay this, my lord. Can the state say no, we are beyond all this, my lord. We don't have to follow any model, my lord. Can they say that, my lord? That is the biggest question, my lord. 2,000 rupees per month, lordship can understand, my lord. Even if person goes for the, my lord, suppose he is called for the duty, even if their statement is correct, my lord. Suppose a person is called for the duty in the day hours, my lord. This entire day is gone. Even for 2 hours, if he is called, the entire day is gone. How can you work anywhere else? This is the issue, my lord. Which, my lord, even if assuming, my lord, their contention is correct. But what we are saying, my lord, we are discharging full-time duties, my lord. And, my lord, we are called upon to discharge our responsibilities anytime, my lord.
Why are you doing it?
The compulsion, my lordship.
There's no compulsion.
Lordship knows, my
It's a part-time work. You don't have to do it. If you get more money
lord.
nowadays.
The employment, my lord.
A boatman will earn more, 2,000 rupees. Why will a boatman otherwise
Knows,
do?
my lord, the situation of employment in this country. I mean,
No, I would have understand it's a confirmed government job. You are getting 2,000 rupees. It is okay. You have a future out there. Where is your future?
my lord, they ultimately, my lord, there are some appointments by the government. So these are appointment by the government, my lord. My lord, it may be part-time, my lord. It may be full-time. That's another issue. But the appointments of the government. So, my lord,
Yeah, next step is asking for pension.
no, no, pension, of course not. That's the reason I'm saying that if at all not, my lord, the minimum wages, at least the minimum wages, my lord, if not the scale, my lord. That's my lord. Our
In
prayer-
fact, I was taking up a matter. We were taking up a matter in the division. This person concerned were initially worked for 34 years now. After working out there, then you see in Nagaland, you have this office memorandum regularized. One is of 2004, then the latest one is 17/3/2000. So there you have to work for 30 years to get this particular. He didn't comply. The judge has passed an order. No, you regularize him and also give him all this pension. Matter came up before this court.
In fact, there is a judgment of Arunachal Pradesh, which is in the record, my lord, given the other day, my lord, where, my lord, under similar circumstances, my lord, the state was asked to make some arrangements, my lord, because though they may not, my lord, fall under any of these categories, my lord.
Huh?
So there is a judgment of Arunachal Pradesh, my lord, but I'm not sure whether it's reported or not. WPC number 482/2011, my lord. It's in Ijum Nongdil, my lord, and 60 others by the state of Arunachal Pradesh.
Then, but the second line of the judgment says that the petitioner being 61 numbers are stated to be working as casual workers in the office of so and so for the last 15 years. It is not part-time.
No, my lord, the finally, my lord, the honorable court, my lord, said that at least some kind of, my lord, benefit should be given, my lord. That's the various, my lord, criteria have been, my lord, taken into account, my lord, and different situations, my lord, have been discussed, my lord. Talks about, my lord, upgrade page 20 and 20, my lord, talks about some upgraded financial package, my lord.
No, but how do you apply Umma Devi?
Uma Devi, in the sense, my lord, first of all, they've been working for more than, my lord, 10 years now. Prior to 2006, they've been appointed. So they're working for that period long, my lord.
I'm not on that. How do you imply Umma Devi? Umma Devi are those persons who have been working out
Right.
without any without any not on the basis of a court's order.
My lord.
One-time exercise be correct. So how do you think Umma Devi?
Well, we are also, well, we are not, my lord, pursuing the court
But
order.
his judgment has relied on Umma Devi.
Well, this doesn't rely, my lord. What I'm trying to say that so far as we are concerned, we are not appointed by any court order. My lord. Neither we are continuing because of an interference with the Supreme Court. We are appointed, my lord, and we are discharging our duty for the last so many years, my lord. One is from 1989. And my lord, the Lord will see the sum which is being paid for 2005. As a model employer, my lord, the state, my lord, can always come up with something, my lord, to at least, my lord, if not the scale, at least they should have.
But how can this court
My lord.
fix the remuneration? Wouldn't that be an absolute authority of the respondents would be the absolute authority to do so?
Respondents and the authority, right? But then the way they have, my lord, they're exploiting these people.
The court at best may say that 2,000 is too less.
2000 is too less, and they can
They may think about 2,500.
and they may consider, my lord, as per the minimum wages, my lord, that's
What?
Minimum wages that is being,
That
my lord,
again,
prescribed for others, my lord. And can the, my lord, that's what I'm saying, my lord. Can the state say, my lord, it's for one rule is for others, all others, my lord, when we are above all the rules, and we can pay 2021, 1021 and do the same, get the same job done, but others have to pay this money, my lord. Can the state take a different stand on that? It's a model employer ultimately. And, my lord, directive principles are also there, my lord. That's to be a meaningful existence, my lord. It's not as if, my lord, the state has can, my
but
lord,
Mr. Datta, don't you think that your persuasive arguments should be better placed before the authorities so that they can take a decision
But
on
perhaps
that,
there's-
and
if
if
there is-
anything happens,
No,
you
but-
can very well come
right,
back.
if there is some kind of an indication from your lordship, some directions from your lordship, then
No,
it's
no,
better.
because
Otherwise, my lord,
you see, the problem is Jagdish Singh squarely doesn't apply. Very difficult.
Jagdish Singh, in one of the judgments, my lord, where my lord, the part-time issue came up. The honorable court held, my lord, that the part-time, my lord, if the duties are similar, my lord, even if the nomenclature is part-time, it will not make a difference.
It's not the nomenclature of part-time. You are part-time, you are not denied to the fact that you are part-time.
No, I'm saying that our appointments are part-time, my lord. That's in the appointment letter itself, my lord. So that cannot be denied, my lord. What I'm
No,
saying,
but
my lord,
they have specifically alleged out there that you are part-time.
Yes.
You have not said it. Yes, I am part-time, but we keep on doing also full-time work.
but what you are
That is
saying,
what
my lord,
we
is
are
that
saying.
we are discharging full-time duties. That is what I've said, my lord. Though the nomenclature is part-time, my lord, we
So
are saying
whether
that
you
we
are
discharging-
discharging full-time duties or not, where is the question of power? How does this court decide that?
Therefore, the regional lottery, there is a lottery, but seen how what amount is being paid to them. Even
Understood.
my lord,
No,
that is
I
also not
have,
being paid
I
regularly.
have all, everything out there that yes, this is wrongly done. 2000 is too less. Nothing you get it with 2000 nowadays in a month.
No.
But you also have to think that there are 35 years people are not getting salaries or, and still working.
That's another issue. That's the state of employment in this country. Well, that's what it reflects, well. Well, it's a more serious concern, well. So therefore, well, therefore the state, well, on its wisdom, if it can provide, say, that you should pay this or you should pay that. On its when it comes to own, can it withdraw its hands and say no, nothing applies to us? Can it say that? That is the issue, my lord. So, my lord, therefore, my lord, the duties they are performing, my lord, at least something it should commensurate with, my lord, or at least, my lord, something which the state is providing for the my lord, asking others to, my lord, follow. Does the state must come up and say, no, we also get to follow that. My lord, lordship will see, my lord, there's even their 2,000 rupees is not being paid every month, my lord. So lordship will understand what will apply to the representation, my lord. Just people are, and there are people, my lord, who cannot, my lord, have the, my lord.
Let me take it up after vacation.
Right.
Let me give a thought on that. What can be done? Yes, I am with you. The 2000 is too less. If something can be worked out.
Yeah.
And just look into all the other aspects, more particularly, there are some hourly payment also the state has fixed.
Right.
Not only primary, let's not go into the minimum wages band, but there is also how it works out there in shops and establishments.
Right.
Look into
Right.
all those aspects.
Sure.
We can bring in something that if it does this also,
Right.
if the state some act says, then why not these other?
Well, I'll look.
I think that is something can be done.
Obliged.
In that.
Definitely.
But I am not agree, with due respect. This court finds it difficult with this judgment, the Arunachal judge, because there Uma Devi has been applied. How do you apply unless you don't come within the ambit of Uma? Principles are there, a lot of principles are there. You can very well apply, but it makes no sense if I can very well apply and give you a judgment that judgment would not be acted upon. Makes no sense.
Lordship is indicated. I'll definitely look.
Look into it that if what happens to a part-time worker,
Right.
there will be some judgment. Because this can't be the first case of that. The part-time has to be there. So how does the part-time get? Now, if the respondent, if the state enforces upon industries to pay part-time this amount, it will be difficult. It can't be applied the same principle.
I've understood this concept.
Because you see, minimum wages are employment in scheduled industries. The
Yes.
part-time concept is not there. Although there is the concept of casual, permanent, everything is there, but the concept of part-time is.
Part-time is generally not there.
But how do you bring in, as per the labor legislation, also if there can be? I think there will be some judgment.
I'll look at it. Definitely.
Heard Mr. M. Datta, the learned counsel, appearing on behalf of Petition. Mr. P. Goswami, the learned additional advocate general, appears on behalf of the Water Resource Park. Mr. P. Gogoi.
Along with me, my lord.
No.
He appears
not a
for-
party.
Yes.
You have not made finance. Who is going to pay?
Even
How?
then, my lord, we can. Even then he can.
No. Without finance, you are going to say yes, but without finance, if he wants to there tomorrow, contempt can't happen.
Not permitted.
Right, law.
So and so, Mr. B. Goswami, the additional advocate general,
Order respondents.
appears on behalf of the water resource. During the course of the hearing, a question arose pertaining to the necessity of impleading the finance department of the government of Assam for an effectual adjudication of the instant dispute. This court is also of the opinion that the finance department of the government of Assam is therefore required to be impleaded as a party respondent to the instant proceeding. Accordingly, this court impledes the Commissioner and Secretary to the Government of Assam, Finance Department, having his office at Dispur, Guwahati, as the respondent number 4 to the instant proceeding. The petitioner hearing is directed to file an amended memo of parties before the registry of this court, on the basis of which the registry shall include the name in the cost title and also update in the CIS. Mr. B. Gogoi, the learned counsel appearing on behalf of the finance department, accepts notice on behalf of the respondent number. The petitioner is directed to give a copy of the petition to Mr. B. Gogoi.
So the FD finance may be reflected after the correction.
No, now it will be done because now with this amended memo, that is why these changes have been brought in. Because what is happened, it otherwise does not reflect. Now, when he files the amended, it will be put out there in the CIS.
Yes.
The registry shall also indicate the name of SC Finance in the cost.
Yes, I'll definitely.
List the matter on when? On 27th of July. I think on this slide.
About 27.
My lord, the matter pertains to my lord, family pension. The petitioner husband, my lord, was appointed with the MR labor, my lord, in the year 1988, in the month of February. Subsequently, he was, my lord, regularized on 23/5/2003.
And when did he die?
He died, my lord, after 1 month, 4 days, my lord, 25/6/2003, my.
Then how do you get the family pension?
Yes, my lord, my lord, as per my lord, Assam Service Pension Manual, my lord. The government of Assam, my lord, office memorandum dated 31/7/2010, my lord. Yeah. Counting of past services of master role workers towards pension, my lord. I have completed, my lord, my husband completed 15 years, 5 months, my lord, altogether. So here, my lord, in case of regularized master role worker appointed against sanctioned vacant post, my lord, my post was sanctioned vacant. Part of their past master role services prior to regulation are to be counted for the purpose of pension in terms of PPG Department OM number PPG E88/2009 dated 25/2009 on attaining the age of separation by the regularized master role worker. As regards pensionary benefits.
Is an office memorandum dated now?
Dated, my lord, 31st July 2010.
But wow, how do you take care of Rule 141?
My lord, 141 and 42 for the, my lord, officers, my lord. Yes, my lord, in 142.
No, the family pension is on the basis of 140.
Yes, my lord, in 141, except as otherwise provided in Rule 142, a family pension not exceeding the.
You are referring to which, where do I get that particular thing? You are referring to the master role where?
But my lord, at office memorandum dated 31/7/2010,
Where do I get that?
page 380, my lord, of pension roll. Page 380.
380. Hmm.
Now, my lord, second para, my lord, in between, my lord, after my lord, fifth line, in case of regularized master roll workers appointed against sanctioned vacant posts, part of their master roll services prior to regulation are to be counted for the purpose of pension in terms of such and such permanent dated 25 on attaining the age of pension by the regular master roll worker. And thereafter, my lord, in fourth, my lord, para, in fifth line, my lord, as regards the pensionary benefit to regularize work charge workers, the master roll period of regularized work charge workers should be counted for the purpose of following these are pensionary benefit. And my lord, as per 108B, my lord, if a person completed, my lord,
Now, that is okay. For pension is okay. But how do you get the family pension? Family pension is under 140. And it says that you have to have 1 year regular service.
100,
Tell me, how do I help you out with that?
140.
Should I apply Rule 67? Tell me how. Give me a way out. Yes, Mr. Hassan. What can be done?
Similar bench or the coordinate bench of this honorable court also pass one order, my lord. By para
Yes, what the
similar situation, my lord, the husband of the petitioner, my lord, S. Jime, was appointed as a
ordinate bench of the High Court, did it take into account 140?
my lord,
How do you take care of that? The 140 says that you have to have 1 year of regular service. How do you take care of that for family pension? Tell me.
for the purpose of pension, my lord, the past, my lord, service of the master worker, my lord, should be, my lord, counted. Then, my lord, my husband has already completed 15 years, 5 months.
Understood. That is okay. But what about the 140? You have not completed 1 year of regular service. How do you take care of that? And 67 can't be brought in under 140. You've seen that?
Yes, my lord. In case, my lord, there is a my lord, provision of 30, my lord,
Hmm.
31, my lord, condition of qualifying service. Right?
That is okay. But how do you bring in 140?
And my humble submission, my lord, in respect of 140, my lord, as my lord, I understand, my lord, except as otherwise provided in Rule 142, a family pension not exceeding the rate mentioned in Rule 141 will be admission in case of death of an officer, my lord. It's especially officers, my lord.
What?
140 and 140.
Then that means you are not entitled to family pension at all. If it is only applies for officer. Eh?
In 142 also, my lord.
As the council, apply. Then we'll look into it. All right, Mr.
And sort of.
And Sarkar, the learned counsel appearing on behalf of the petitioner, Mr. A. Hassan appears for the Accountant General, Mr. C.R. Sharma appears for
2, 3 and 4. Thank you.
2, 3 and 4. And Mr. B. Gogoi, you are there for finance, and Mr. C.S. Hazarika for the Director of Pension.
Here for PW, more than one PW.
Treasury,
So PW,
you are paying for Mr. B. Gogoi appears for the PWD and
that's one of my 8 members, not directly, but
Commissioner
secretary of the pension.
Finance.
appears for respond number 8. Let the matter be listed after vacation.
Finance.
Mr. Sarkar, the answer you can find, see one judgment of Uday Pratap Thakur. You'll have a look at. If you can bring in that particular notification read with Uday Pratap Thakur, I think you can bring it. But before vacation, why should I take the
What? At number 28 to 30.
Yes, Mr. Saikia. Don't tell me you are with the stenographer, man. Stenographer?
No, my lord, this is copies, my lord.
Oh, that one, the
My lord.
copy. Yes, Mr. Gogoi. Why he would not be entitled to the equal pay?
Well, it will be after vacation, man. At 4 o'clock, man, this matter it will take.
Hello. Anyways, I have to dictate 2-3 judgments of the division bench also. Hello, let the matter be listed after vacations.
Lordship, it's a dead.
Huh?
It's a dead.
Yeah, have it on when? 8th of August?
Well,
31.
Yes.
Thought it. The lordship file issuing notice at specialized basis.
Matters pertaining to what?
Pensionary benefits, my lord.
Ultimately, pension.
Pensionary benefits.
It will involve the interpretation of a division bench judgment. Earlier, he was dismissed. If your lordship have a look at your lordship's order 19/12/22, the first order.
Ah. Oh, this one?
The instant registration has been filed challenging the communication dated 22/12/22, whereby amongst others, it has been mentioned the petitioner would not be eligible for pension for total service in the bank after deducting the unauthorized absence comes to 14 years, 11 months, 20 days. Ernest so has drawn the attention of the court for the judgment filed by the division bench of this court on so, wherein it has been mentioned the petitioners have been serving for the last 22 years without any adverse remark or report. It submitted that the said observation has been arrived at by the division bench of this court after hearing both the parties and as
You file your affidavit.
Well, yes,
pleadings are complete.
This is relating to our interpretation of what?
Your lordship, initially he was dismissed.
my lord,
without-
only.
Please.
Huh?
The initial round of litigation, my lord, the petitioner was dismissed without notice. The single judge affirmed that when the matter went to the division bench, the division bench said that the punishment is disproportionate. There are certain observations regarding pensionary benefits also. There, both the parties proceeded, but the division bench also records that he had served for 23 years, taking the initial service and the discharge order. That comes to 23. After that, and they said you pass some other orders which is more lenient. They pass an order, now they passes an order, I am discharged with pensionary benefits and gratuity as per applicable law rules. Now, so far as gratuity they have granted, but pensionary benefit they have denied on the ground that you require 20 years of pensionable service. So one is
As per their rules.
rules. Rules also there is, I mean, that is my alternative submission. If you lordship, there is alternately even 10 years service one can grant pension. But first submission is how do we the interpretation, what did the division bench, because the division bench made observation about pensionary benefit also. The whole idea was that you grant a punishment so that his pensionary benefit is somewhat protected.
And
Now,
he never said that.
at that point of time, we had placed in the writ appeal that during these 4 or 5 years, it was in the pleading that in 2003, he got voluntary resignation. It was not accepted. A lot of communication. Factually, it is correct that for 4 or 5 years, he didn't work. So, I mean, on facts, I can't go and say no. 23 comes, initial joining 87, dismissal of 2010. They, strictly speaking, if your lordship say what they are trying to canvass today, strictly speaking, because leave without authorized without any authorization will not count for pensionary service. But sometimes your lordship, while granting relief, also take into or the treat
deemed continuation for pensionary benefits. So how the division bench, what is the real purpose of the division bench is one aspect of the matter. The second aspect, whether alternatively there was provision for giving grants of pension, because there is some provision which indicates that even 10 years is sufficient if you are in service on or after 87, right? If you are in service on or after 93. So I was in service since 87. So these are the two aspects that is really the matter, and straight away I can place the division bench judgment.
My lord, the honorable court has to look into two things. Whether he has completed at the time of his removal was he 50 years of age.
How much?
50 years of age.
Oh.
Was his, there are two criteria. One is that he has to be 50 years of age and this continuous 20 years of service.
Both.
So it's a long.
Your Honor, my lord, the observation has been made by themselves also in the pleading that there are two criteria. One is that he has to have 20 years of pensionable service, not service, pensionable service. And second is that, Your Honor, he has to have 50. Now, admitted fact, both are not qualified. He has not completed 50 years of age, and pensionable service, in order to compute pensionable service, 20 years have not completed.
Mm.
So that is the difficulty.
Your Lordship may just see the operative part of the division bench at page 75. It's just 2-3 pages. Background, Your Lordship, I have told my lord, it was an order of dismissal which was put under challenge. Para 9 on paper. We are also of the view that there cannot be any doubt of the concern raised by the bank about such a conduct of the appellant. However, we have taken note of the fact that the appellant's act did not result in any pecuniary loss to the bank, nor there any element of doing any favor to the member of the public or engaging in any conduct which would tend to lower the prestige or goodwill of the bank in the eyes of the public. It was certainly an act which was not expected of an employee, but we have also noted that the appellant had readily admitted to his charge by not contesting the same, as tried to explain the same by stating that he had utilized part of the loan amount for purchasing a plot of land and constructing a small house for his aging mother. We have also noted the dismissal is Your Lordship may then come to para 12, 11 and 12, my lord, page 76. We have observed that the appellant had been serving for the last 23 years.
Mr. Goswami, these paragraphs where the division bench holds it, two aspects are there. First of the aspect is the issue before the division bench or before the single bench was as regards to termination. The second, the division bench was making these observations only for the purpose of holding as to whether
Proportionality of the punishment.
it was disproportionate or not, the proportionality of the punishment.
But they were present when all these observations. But if Your Lordship, that's why I'm just reading my lord 12, if I read my lord, 2011 you've already known, Your Lordship must have known. If the appellant had served.
I've read that.
11 Your Lordship has
I've read it.
12 also.
12 also. The
12
first line.
is slightly, I want to place emphasis, my lord.
But Mr. Goswami,
We
see
are
the
not-
last line of paragraph number 9 with due respect
Ah.
to the division bench.
My lord. My lord.
It was certainly an act which was not expected of an employee, but we have also noted that the appellant have readily admitted to his charges by not contesting the same and have tried to explain the same by stating that he utilized the part of the loan amount for purchasing a plot of land and for construction of a small house for his ailing old mother.
Loan, it is a bank employee took the loan for himself to construct the loan. It is not the loan that he had sanctioned to another person. The loan was given to him to construct the house. He utilized it for purchasing a plot of land and building a small house for his mother. So he has misutilized the loan which was sanctioned to him. That is the Lordship would
Is
appreciate.
that the reason?
Yes, ma'am.
It is not as if he has-
Basically, Honor, he was not supposed to do that. Because what happened,
whenever a loan has been sanctioned, Your Honor, it has been sanctioned for a particular act, Your Honor.
What are you going to do in respect to other people? If a loan is sanctioned
My lord.
for buying a flat
Huh.
and he purchase a land, what are you going to do?
No,
with
no, we
that?
are not going to give, Your Honor. That is why what we are doing.
You have already given.
No, no. What happened, Your Honor? This was the manager himself who misappropriated that money. Your Honor. That is not
I'm a computer operator.
sanctioned by bank, Your Honor. A money which has been given for a particular use has to be used in that manner. It cannot be changed. That is why nowadays what is
No, no.
happening.
What do you do if some other customer does? Then what do you do?
No, we file a police complaint, Your Honor. We recall our loan
Ultimately, your loan has been
because that is
repaid.
something a breach of contract, Your Honor. He has entered into an agreement indicating that I am going to purchase one plot of land. Now, what is happening these days, my lord? In order to have a check, we issue a check directly in the name of the purchaser, the seller. So that is some kind of caution we are taking care.
Have you challenged that order of this discharge? No.
That discharge because, my lord, the problem arises with the second order we have challenged. That is why we are before your lordship.
You have
The
challenged that.
denial of pensionary benefits is what brings us to your lordship, my lord.
But have you challenged that discharge?
Discharge, dismissal, that discharge we have not. That so far as the loan is concerned, my lord, your lordship sees 237 of their affidavit. Ultimately, there is a compromise agreement between the parties and the loan is fully repaid. That is why the division bench says it does not embarrasses the bank, because if he had done it to a customer, then it would have been a whole different complexion. And if your lordship just have a look at para 12 once more, my lord. If the appellant had served for 23 years without any adverse remark or report against him, we are of the view that dismissal is the highest form of penalty, which would entail denial of any service benefit, including pension perhaps. The whole idea of the division bench was also to protect the pension. They may amount to be very hard. We also take into account that the aforesaid misconduct of the appellant, no pecuniary loss was caused to the bank. We have also taken into account that it was an internal administrative act of the appellant which did not come in the public limelight, which would have caused embarrassment to the bank. We are also seeing that the appellant at the first instant apologized for his misconduct and also offered the reason for doing so. Therefore, under the circumstances, we are of the view denial of benefit of the entire past service rendered for 23 years.
So is it your case out here that the order by which they have passed, the disciplining authority had passed the order amounts to denial of the pension?
Right.
But you have not challenged that order.
Denial we have challenged.
No, denial subsequently you have challenged.
What discharge says you're entitled to pension as per rule, applicable rule. The order of there is the.
So in a sense, they have put.
At that point, then comes the order of applicable rules by which they grant gratuity but deny. But even on the rules, if your lordship sees it is placed in their affidavit in reply. There are many components to the rules. If your lordship sees 110 in their reply affidavit.
110.
Right.
So completing 20 is pensionable period.
Rule 20. The lordship has rule 22.
Yes.
Right. A member of State Bank of India Employees Pension Fund shall be entitled for pension under Rule 22(1) while retiring from bank service after having completed 20 years of pensionable service, provided that he has attained the age of 50. This is what they are only looking at this. Or if he is in service of the bank on or after 1/11/93, my lord, he joined on 27/2/87. So on that date, he was in service after having completed 10 years of pensionable service. So this is also available to them. They may consider, provided that he has attained the age of 58.
today, well, on the date when the impugn order of was passed in 24/11/22, I had crossed 58. I'm August 64 born. Further, if he is in service of the bank on or after 22/5/98, after having completed 10 years of pensionable service, provided he has attained the age of 60. So there are, whether they can apply.
You won't come in the first portion, you have to come under the second.
My lord, first rule I'm saying is on the observation of the division bench.
No, yeah, no, the first two lines of clause B would
Right.
not be affected in your case.
Well, if he is in service of the bank on or after 1193, on or-
Understood?
Huh.
This is only in respect, because there is a modification thereafter by the other, the 22/5/98.
the lordship is
In that very clause, there are two respects.
my
If
lord.
you are in employment after 1/11/93 and have done 10 years and have attained 58, you are entitled to. Then in the case, if it is after 22/5/98, you have to be 60.
And I'm on either one of I want to get some pension, my lord. I want to fall in one of the lordship is right. So be the first part, maybe I may fall, but the principal argument is where in those proceedings there are observations from which one can read that the division bench also wanted to protect the pensionary benefit. And the facts were such-
You're short by how much?
no, if they are
No.
short by 5 years or 14 years, 11 months, and some days. So about 5 years.
No, not
and,
that 5 years can be taken care of by 10 years. That can be taken care of
this is the
pensioner, but
alternative
what
fee.
about the 60 years? What can be done with that?
No, that if I am in the first category, I think I'm entitled.
No, you are not in the first. You are in the second.
Neither in the second, my
the,
lord.
the first part.
My lord,
He's
he has
not
co-
first.
my
You
lord-
you have to come on the second.
My lord, he has completed only 45 years of service, my lord.
No, not
When?
14 years.
No,
14
45.
years, 11
His age, my lord. His age is only 45 years.
When?
No. I am
On the date of his removal from service, my lord.
No,
now the
not
after
on that.
division.
Because you see, the moment the court sets aside
Yeah,
the
that is what.
termination, the termination has been set aside and asking you to take a call. His termination is not there.
My lord.
So he may not be having a pensionable service because he has not been working for that. But for the other purpose, he was there as on that day till your order was passed by the disciplinary authority.
Correct, my lord.
14,
Then
11.
the calculation of pensionable service has to be taken into account.
For that, he has 10 years.
No, my lord.
Why?
Oh,
You yourself say that it is
Ah,
14 years.
correct.
Then
24/11/22 is the sorry.
It attains 58 years. 58 years means from the date of passing of the second order.
24/11/22.
that is what I asked them. Have they not challenged? Why
No,
haven't you
That
challenged
is
it?
quite
Why haven't you challenged the second order? It would have been a continuation of the previous.
consequences were felt by the second order. We were hoping that it got protected, but your lordship is right.
If something is there,
If your lordship is satisfied that it is in breach, the first part is only if your lordship holds that the observation, they can shy away from the observation, those 23
Mr.
years.
Goswami, I have said many things. I think you better think about it. Challenge the second order.
No, my lord, because we'll-
Challenge the second order. Once you challenge the second order, it will be a continuation, and then I can link it with the writ appeal order. Otherwise, it is very difficult.
I quite see
And then you become again 60 years.
my at 60, if your lordship, I just wanted to, it is independent of 58. Further is it is there. So
Understood. So this key, how do you bring yourself in 60?
no, I don't fall
You
in
have to check.
I would fall in the 58 part.
How do you fall in 58? Because it's on 1993, but before the 98, you
On
have to be.
insurance service on or after. On I am in on it-
On or after 93, but that will only apply because I think they must have changed the date of retirement as 60 in 1998. That is why they bring in that. So this was after 1998. So it will be 60. So the only way is to challenge this order of that order and amend the petition and bring it out here. And then that order can be touched with that writ appeal order and then some consequential. Otherwise, you have no problem. Women's no way out. Okay, heard Mr. P.K. Gustafin, the Learned Senior Counsel, assisted by Mr. B.P. Bora. Mr.
Take a seven.
To enter appears on behalf of the respondent State Bank. Mr. The Senior Counsel has submitted that he would like to take instruction in the matter, list the matter after. Do the needful, that is the only way out.
I was thinking because 58 on the date when the impugn order was passed, he had crossed 58.
No, that won't help you because 98, most probably you have become 60, na?
Yes.
The 60 years was there for retirement. So that is why it's just 98.
We'll have to look into the history of the provisions of why it has brought about. Deeply of that.
32.
Deeply.
Much of that.
What, Mr. Nair? This matter has not finished. I thought this matter has. I've washed my hands out of it.
No, Mother, we are waiting for Mother.
No, it can't happen before vacation. How is it possible?
Mother will fix it on a convenient date. Mother.
Heard Mr. UK9, the Learned Senior Counsel, assisted by Mr. H.K. Das. Mr. J. Patwari appears for the respondent number 3.
3, 4, and 5.
3, 4, and 5. Mr. I. Chaudhary, the Learned Senior Counsel, assisted by. Appears for the respondent number 8. From a the records reveal that all the pleadings are complete. The Learned Counsel, appearing on behalf of the respondent number 3, submits that there is an order of stay operating against the appointment of a register.
There is a stay against the advertisement. The new advertisement.
Against the
Yes,
stay, there is an order of stay against the appetite, and as such, the matter needs an early disposal. Accordingly, list the matter again on 27th of July.
Much of it.
34.
Yes. Yes.
Lordship, in this matter, I need some more time, my lord.
Mr. S. Dr. the Learned Counsel, appearing on behalf of PNRD. 6 for an accommodation. For
4 weeks time, my lord.
for
4 weeks time, my lord. After vacation.
why?
Lordship, actually, this belongs to my lord, to mission 1 mission.
Why do you want?
For instruction.
What is the matter?
Lordship, regarding the suspension, regarding my suspension here,
You are suspended.
suspended.
Hmm.
Suspended
Because
and suspension was withdrawn. Subsequently, I am, propose was issued. I replied. Subsequently, verbally, I am asked not to attend the OPT.
But you are getting your salary.
No
Why
salary.
you are
He
not
was
paying?
honorarium basis, my lord. He was, and that was.
What is this suspension of this type of honorarium business?
Lordship?
Is he a permanent employee?
No, my lord.
Temporary employee.
Temporary employee.
How is he a temporary employee?
Lordship,
Temporary employee has to be a temporary post. Is there a sanctioned post?
he's under a mission, my lord.
Then,
Not directly under Panchayat department.
where is the question of applying this,
Yes,
all
ma'am.
these things? Order, rule 6 and all.
No, my lord.
Huh?
No, not like that, my lord.
Then,
And after 2020, he is before court only 2023, my lord.
okay, heard me. As the third 6 point accommodation, list the matter on 26th of July,
My lord.
2023.
Highly obliged.